Thanks for pronouncement of judgment. Item number 28, WPC 4283 of 2021.
Petition allowed.
Item 29, WPC 660 of 2023.
Petition allowed.
Item 30, this is CRT IO 116 of 2023. 2025.
Petition dismissed.
My pleasure, Lordship. My Lord, I am praying for listing one motion tomorrow, my Lord, because before the court below, it is fixed on 20th April, my Lord.
When?
20th April, 20 April.
Tomorrow as the last item, we will try.
Yes, Lord. Much more.
Lordship, I beg to mention item number 16 of the list. Lordship, it may come up after 3 weeks, Lordship. Actually, the file containing the original certified copies has been misplaced. So we will obtain a new, fresh certified copies.
Your good name, please.
3 weeks, Lordship.
Your good name.
Yes, Sharma. Yes, sir.
Mr. S. Sharma, learned counsel for the appellant. Price for listening the matter after
3 weeks, Lordship. Deeply open.
May I please, Lordship? Mention on listing in IA in RSA number 225 of 2016. The I was filed on 4/2025. My Lord.
when do you want?
As convenient of the court after
Last week of April.
Last year.
May I please? Consent taken from the opposite party, Lordship. I beg to mention item 26, Lordship. I'm paying for adjournment, Lordship.
Hearing.
Okay. As agreed by learned advocates of both the parties, receive and list the matter. On 6th of memory.
No, Lordship, not 6th. On 20th, 20th of May.
Yes.
May I pray, Lordship? I beg to mention for list.
So many cases already. May not 29th May.
May I pray, Lordship? I beg to mention for listing of 2 bail applications tomorrow, so earlier rejected by your Lordship. Tomorrow also only I will pray for calling for the case diary. Offline.
May I please, Your Lordship? I beg to mention for listing of 2 MFAs, Lordship. Both the matters are pending before the Honorable Court for both the matters are for all pending matter, Lordship. So that will be come up after verification, Lordship. Obliged, Lordship. Date.
May I please, Your Lordship? I beg to mention for listing of an RSA matter any date after vacation for orders, Your Lordship.
For orders on 25th,
April.
25th April.
I'm deeply open.
Top of the list item, item 31.
May it please, Your Lordship. My Lord, in this matter, my Lord, on the last occasion, my Lord, Your Lordship wanted to know as to whether there are any judgments of the Honorable Supreme Court regarding, my Lord, non-production of the seals that are affixed by the OC, my Lord, under section 55 of the NDPS Act. In that regard, my Lord, I found that, my Lord, in Nuraga's judgment, which I've already placed, Nuraga's judgment, my Lord, there is a quote on this, my Lord. Nuraga, my Lord.
Yes.
135, para number 135.
Yes.
May I read, my Lord? We cannot but also take notice under other discrepancies in respect of the physical evidence, which are
You are reading paragraph number?
135, my Lord, at page number 23.
Yes,
We cannot but also take notice other discrepancies in respect of the physical evidence which are the bulk was kept in cotton bags as per the Panchnama exhibit PC, while at the time of receiving them in the Malkhana they were packed in tin as per the deposition of PW5. The seal, which ensures sanctity of the physical evidence, was not received along with the materials neither at the Malkhana nor at the CFSL and was not produced in court. Physical evidence of a case of this nature being the property of the court should have been treated to be sacrosanct. Non-production thereof would warrant drawing of a negative inference within the meaning of section 114G of the Evidence Act. While there are such a large number of discrepancies, if a cumulative effect hereto is taken into consideration on the basis whereof the permissive inference would be that serious doubts are created with respect of the prosecution's endeavor to prove the fact of possession of contraband from the appellant. So if the seals are not produced, some amount of doubt is created regarding if there is any possibility regarding tampering when the seized contraband is still in the custody of the police and is yet to be produced before the magistrate. So whether those seals are affixed or not, that can be
the samples were drawn in presence of the magistrate
magistrate.
and
But
this
the seals are to be,
inventory was prepared.
yes, but the seals are to be actually, my lord, affixed once the informant hands over the seized drugs to the OC under
That
55.
decision is of which year?
2008, my lord.
2010.
2008. 8.
And thereafter this Mohanlal decision is of 2017,
2016.
16 or 17.
16.
Did you ask any question to the IO at the time of his examination before
No,
the
no,
trial
no.
court?
No.
So having not raised the issue before the trial court, are you entitled to raise the issue before this court in appellate
Since it's
stage?
an issue of law, my lord, my humble submission is that, my lord, that can be raised at any stage, my lord. Since it's a matter of record, whether seals were exhibited or not, and from the record it appears that seals were not exhibited. So perhaps, my lord, I will be entitled to raise that issue, my lord, even at the stage of appeal, my lord.
Are you?
But that's my humble submission, my lord.
Yes, Mr. Sharma?
Regarding that part, my lord, seal, my lord, not exhibited. That is,
Pardon?
my lord, seal, my lord, that is not exhibited.
Exhibited.
Not exhibited, my lord. From the record, my lord, I have also gone to my lord once again, my lord, in yesterday. But that question was not put for the IO, my lord.
Okay, any other point?
And the remaining point is the medical issue, my lord. Health issue of the applicant number 1.
No, we will decide the merit on, no, we will decide the appeal on the basis of merit,
My lord,
not on the health condition of the
my lord,
appellant.
my lord.
Pardon, sir, is thus learned counsel for the appellant, Mr. D. Sharma, learned additional review for the statement. Argument concluded, judgment is
Here for motion, bill application.
Highly obliged.
I just one.
Your lordship may pass over the matter for the time being. The arguing counsel is on legs in another court. Much obliged.
Motion item two.
May please is your lordship. Lordship, this CRP is filed because for as per the amended Motor Vehicle Act, lordship, the claim petition is to be filed within 6 months as per section 166(3). But it was filed beyond that time, lordship, beyond 213 days. 31 days delay, lordship.
So the matter is pending before the Supreme Court.
Supreme Court, lordship.
When the matter is listed,
I don't have any
you
idea,
have
lordship,
no idea.
but it is pending.
Let notice go at this instance. Pardon is
And lordship may state a proceeding.
Learned. Mazumdar. Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 28/10/2024, passed by the learned member Motor Accident Claim Tribunal Supervisor in MSCT case number Miss Gutenberg Jay, MSCT case number 5 of 2024. It is to be noted here that by impugn order dated 22, the learned tribunal has allowed the petition under section 5 of the Limitation Act and condoned the delay of 231 days in filing the claim petition referred by the respondent herein. Files the petition and the documents placed on record and also files the impugn order dated 28/10/2024. Let notice be issued to the respondent, returnable in 4 weeks, shall be taken by registered post with PD and also by legal process within a week from today. Ms. Mazumdar submits that there is a requirement for staying the operation of the impugn order dated 28/10/2024. As the same was passed in absence of any statutory provision of law. In absence of any statutory provision. Statutory provision. As section 166 of the Name MD Act does not provide for condemnation of any such delay. Taking note of the submission of Ms. Mazumdar, learned counsel for the petitioner. The impugn order dated 28/10/2024 stands to state daily returnable at least after 4 weeks.
Highly obliged.
May it please, your lordship. My lord, my application for appointment of a commission for a local investigation was rejected, my lord. Now, my lord,
Before hearing argument, is it permissible?
my lord, it says at any stage and having regard to the facts, my lord, if your lordship may kindly come to page 12, my lord, just to indicate the nature of the dispute. In my respectful understanding, a commission was indispensable, my lord. My lord, para 13, if your lordship sees, page
That
13.
too, it is a discretionary power.
It is,
The
it is,
trial
my lord.
court.
It is, my lord, but I'll just indicate the facts, my lord. Page 13, paragraph 2, if your lordship sees. This is the plaint, my lord. The dispute was essentially a boundary dispute concerning identity, my lord. Let's now, my lord, sees paragraph 2, my lord, at page 13, that so and so Shishuram Das, since deceased, the predecessor in interest of the pro forma defendant was the original owner of the suit land along with some other land of the suit Dag, said Shishuram Das was in need of money, so he sold the suit land to the plaintiff by a registered sale deed bearing registration number so and so and delivered possession to the plaintiff. Now, your lordship will mark, in the schedule of the said sale deed, the cardinal point is wrongly described. Actually, road is in the eastern side, so the boundary should have been north, south, so and so, so and so. Now, paragraph 3, my lord, that the plaintiff after purchase
No,
obtained.
if it was in your knowledge from the very beginning,
It is.
why you awaited till hearing of the argument?
My lord, we had the witnesses were cross-examined.
Is it not the delaying practice?
It is not, my lord. Therefore, I will show, my lord, why it is so indispensable, my lord. Now, page 14, paragraph 3, my lord. Then the plaintiff says, my lord, the plaintiff after purchase obtained possession and got his name mutated. Plaintiff and his vendor before purchase, as per rule, obtained by the permission, obtained permission from Town and Country Planning. The permission was granted along with a sketch map. In the sketch map, the area specifically mentioned. In the said permission, with the sketch map, the area was shown as 38 feet in breadth, 189.45 feet in length, and in the northern side, there is a strip of land belonging to a vendor of the plaintiff measuring 8 feet in breadth, and the said strip of land touches the remaining portion of the land situated in the western side. Now, that after purchase, the plaintiff erected boundary walls. Now, if your lordship sees the schedule at page 16, it indicates my possession on the west. Now, two things, my lord, very relevant in my understanding emerges, my lord. First of all, plaintiff himself says that my boundary in the sale deed is not correct. Then he goes on to explain dimensions of a path. I am situated both on the east and the western boundary of the plaintiff's land. And during the cross examination, my lord, at page 28 onwards, your lordship will find there were hand-drawn maps, not drawn to scale, relied upon. Page 28 onwards, my lord. This is exhibit. These were exhibited during the course of evidence, my lord. This is exhibit 5. Then at page 30, there was another map relied by the defendant and another by the plaintiff. So page 28, 30, and 32. All of these are hand-drawn maps, my lord. Two of them do not even have a scale. Now the question is, my lord, the sale deed, the plaintiff himself admits the boundary is incorrect. My lord, he gives
Where plaintiff has admitted it?
Page 13, my lord. Now, how is the court supposed to even find out, my lord? Paragraph 2, my lord. In the schedule, last but 4 lines from the bottom. In the schedule of the said sale deed, the cardinal point is wrongly described. Now, amidst so much of uncertainty, my lord, the sale deed is not correct. They're relying on hand-drawn maps, my lord. These maps are not drawn to scale. There are disputes. He says it is 8 feet. I say it is 10 feet, my lord.
No, those are the questions to be decided by the trial court at the time of hearing.
Now, my lord, we'll see the impugned order. Impugned order doesn't even take note of the dispute, my lord. Page 43, if your lordship sees. The essential question is it's a boundary dispute. Nobody visits the ground. They'll have to rely on these documents. These documents are hand-drawn maps. The plaintiff himself says that my sale deed is incorrect. Now, how will the court come to a finding, which is why, for the purpose of elucidating the controversy, a commission in such a case, at least, my lord, was indispensable. My lord, the court could have done it on its own motion. Page 43, my lord. Now, my lord, the second last paragraph, my lord. Before that, my lord, it's just stated what has happened so far. On perusal, it appears that the instance suit is filed for right title and interest and confirmation of possession, recovery of possession, partition, and for permanent injunction. On perusal of the material on record, it is also found that local investigator of the suit is not required for the purpose of elucidating the matter in dispute of the instance suit. Now, my lord, in such a case where there are differences between what the measurement or the dimensions of the common path is, we are boundary man, our sale deeds are not in dispute. The plaintiff himself says my boundary is incorrect. All the court has are a few hand-drawn maps, my lord. How will it even ascertain whether there has been an encroachment of 6 feet as is alleged by the plaintiff in the plaint, my lord? Now, 26(9) is very clear, my lord. It could have been done at any stage, my lord. And therefore, all it requires is one appointment of a commission that thereafter the matter can proceed for argument. The only anxiety is if on these available
No,
records,
no, thereafter, again, the question of adducing evidence, cross-examination, those points will.
That exercise under Rule 10 obviously has to be followed, my lord. I agree. But beyond that, your lordship may observe also that no further evidence except for the
No,
commission.
no. How can I observe it? If some things come out in the commission,
Huh.
from the report of the commission, then the occasion, there may be occasion for.
True, my lord. But
examination of
just to
some-
expedite the trial, my lord, in such a boundary dispute, if the court is permitted only
No, the question is why you have waited till.
My lord, we waited because,
There's
my
no
lord,
argument.
these maps were introduced during the evidence. They were, I can produce the cross examinations also. All cross examinations indicated, my lord, that everything is very vague here. Because ultimately they don't have any documentary proof as to show the length and breadth of the common path, the how much the suit land or my land measures, my lord. Ultimately, we are boundary men, my lord. And the allegation is that I encroached upon somewhere to close to 6 feet, my lord. Now, this 6 feet to determine whether, because ultimately even the depiction of the road in the sale deed is wrong according to the plaintiff's own admission. So how does the court even decide, my lord? And does it not require an elucidation insofar as the identity is concerned? Because if your lordship sees the map at page 28 for a moment, my lord. Now, this is the map, my lord. Now, he says, my lord, I'm there on both the sides, my lord. I'm there on both the sides. Now, he says, my lord, that I've encroached somewhere here, my lord. How does the court even get a clear picture of what's happening unless there is some material from a person to a local investigation or a spot verification, my lord? Now, he says it is 38 feet. I say no, the breadth of the entire plot is less than that. And then, my lord, there are other maps.
Enclose the evidence.
I have
Yeah.
not, my lord. I have copies. I have copies.
You file it by way of an affidavit, we will say.
My lord.
When the next date is fixed.
My lord, next date is in one. Next date this time, my lord. I can file it before that.
Pardon?
Next date there is time. It is fixed on 16/5. So I can file it before that and your lordship can consider.
Heard Mr. Billy Decker, but I don't for the petitioner. Leaves the matter.
On 9th May, Lordship.
Nine.
9th.
Okay. So enable Mr. Decker to produce before this court the evidence recorded by the learned trial court by filing an affidavit.
Obliged.
Item 4.
It pleases your lordship, my lord. My lord, here, my lord, you have challenged the order, my lord, at page 57, my lord. That, my lord, lordship now kindly order dated 12/3/2025. Relevant portion, page 58, my lord, Ferus, from the middle, my lord, it appears, page 58, my lord. It appears that the plaintiff petitioner wants to insert paragraph 8(1), almost repeating page 58, my lord. And this, my lord, this is an application he filed under section, order 6, rule 17 for amendment of the plain. But my lord, kindly say page 58 from the middle of the paragraph, my lord, it appears that the plaintiff petitioner wants to insert paragraph 8(1), almost repeating the facts that the plaintiff is one of the co-legal heirs of late Girikanta Saikia, and as such, she is entitled 1/4 share of the property of Girikanta Saikia as a right of inheritance. And next, my lord, in paragraph 8(2), it appears that the plaintiff, apart from repeating the fact that she is entitled 1/4 share, has specially sought out of the area of land which she claims from each of the schedules, so and so. And thirdly, my lord, 8(3), petitioner prays for making Dilip Kolita Mondal the party to the suit, alleging that he is instigating defendant number 1. My lord, now, next page, my lord, I have meticulously gone each of the prayer as regard 8(1) and 8(2). It appears those paragraphs are already stated facts in the original plaint. If amendment is allowed, the same will not change the nature and character of the plaint. Rather, specific details of the suit property claimed plaintiff as mentioned paragraph 2 would help the court in deciding the real facts in this. However, Dilip Kalita Mondal is not necessary party in the suit as there is no right of claim over the suit property in the manner such this present is not necessary. Therefore, above the proposed amendment as mentioned in paragraph 8(1) and 8(2) allowed, 8(3) not allowed. My lord, against the allowing an amendment under 8(1) and 8(2), and before this honorable challenge this order, I am defendant number 1. My lord, on the ground that, my lord, order 6, rule 17, my lord, in my humble submission, for insertion of facts or information which are not pleaded earlier in the original plaint, but for repeating the same statement, that power is cannot be exercised in my humble submission on this ground, my lord. Lordship will examine this, my lord, and this is the same judgment on the same count. Already here also in the Honorable Supreme Court, my lord, already pleadings was available. And for repeating the pleadings, this power under Order 6, Rule 70 amendment cannot be exercised. That is the case, my lord. And Lordship, in fact, in the plain I can show, my lord, that how this has been repeated. Page 22.
When
Our
the
claim
next
is
date
in,
is fixed,
my lord,
when the next date is fixed,
5/5, my lord. Well, therefore, my lord, Lordship may examine because it is not
Let
covered by the
notice go.
Supreme Court decision also, my lord.
let notice go at the sixth.
My lord,
Let the other side come.
we require to file my amended application now again, my lord. So, my lord, till the next date, Lordship may consider page
No,
12,
before next date, we will consider it.
my lord.
Let notice go at the sixth. Heard Mr. Das learned product. This petition under Article 227 of the Constitution of India, the petitioner is telling the correctness or otherwise of the order dated 12/3/2025, passed by the learned civil judge, seniority with the foreigner. We check is part 57. This domain operated by the film order dated so and so, the learned trial court has allowed amendment of the plaint.
Which is already in the plate.
Amendment of the plaint. Where is the petition and the documents enclosed there at the impugn order dated so. That is be issued to the respondent and returnable on, sorry.
First week of May, Lordship.
Uh,
5th May,
no, it may
5th May is
be
the suit fixed, my lord.
30th April.
separately taken by registered post with AD and also by usual process. We can report to them. Interim pair will be considered on next time.
My lord.
Item 5.
Oblige, my lord, oblige.
Wait, please, Lordship. Lordship, the petitioner is the plaintiff decree holder of the execution proceeding. But the petitioner filed a suit for eviction of respondent number 1, who is a tenant of one Kacha shop room. Hello, may kindly come to page 34. There, Lordship will find the decree because, my lord, respondent number 1, she did not turn up.
So, Mr. Dotto, you tell me who instituted title suit number 8 of 2022 and 6 of 2022.
6 and 7, I have instituted, my lord. I have instituted against 2, 3, and 4, my lord. Because, my lord, all these, my lord, respondents are tenant. They are occupying different rooms of my Kacha house. So I instituted 3 different suits for eviction of them by filing 3 suits.
How does schedule become same for all the 3 suits?
My lord, issue was, my lord, we have prayed, the court has mixed up the schedule of a 1 suit room with the schedule of the land. Because schedule of the land is same, because the house is situated on the same dag, same patta. But there are 3 different shop rooms. And the 3 shop rooms were occupied by one by the respondent number 1, one by respondent number 2, and one by respondent number 3 and 4. So for eviction from the suit room, as because they are defaulter in paying rent. So I instituted along with my deceased brother 3 suits.
So show me the plaints of this 6 and 7.
6 and 7 I have not annexed, my lord. Because here, my lord,
Then how can I appreciate the fact? If you have not placed it on record.
6 and 7 I have not annexed. But, my lord, admittedly, my lord, there
Is it
must be
with
a,
you?
my lord.
Is
Yes.
it with you? You file an affidavit enclosing those
Obliged.
plaints of both the suits.
Yes.
And the suit relating to this execution proceeding also.
My lord, in this case, my lord, I have annexed the plain, my lord.
You have an ex.
Yes. Annexer,
And the other two. When the
Annexer
next
1.
date is fixed.
my lord.
Next date is
My lord, my execution proceeding has been stayed, my lord. By saying that, my lord, until and unless that suit were decided, this should be stayed, my lord. When there is no question of disposition.
aware of the recent decision of the Supreme Court where it is stated that within 6 months decree has to be.
Yes, that judgment I have, my lord. Even in that particular judgment also, it is very much clear, my lord. There must be disposition first. Then the question of filing application under 21 Rule 99 will come. Here, there is no question of disposition, which is apparent from the petition which they have filed. And I have annexed it.
You bring on record those plaints by filing an additional affidavit. Okay. Immediately after reopening. 28. 28 Part Mr. M. Dr. Learned Counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has selected the correctness or otherwise of the order dated 24/1/2025. Passed in title execution case number 2 of 2024 by the Learned Civil Judge Junior Division number 2, Gulagan. Is to be noted here that by the execution order dated so the Learned Executing Court has state the execution of title suit number
8/2022.
no, decree will be executed in the execution suit.
Yes,
Title execution case number 2.
Execution case number is 2/2024. And the execution is for title suit number 8/2022.
No, that case has already been disposed of.
Yes, disposal.
Title execution case number 2 of 2020. Now, who is proceeding state?
Execution proceeding stayed, my lord. My execution proceeding, which I have.
What you have mentioned in your this first title?
My lord, interim order dated 24/01/2025 passed in title execution number 2/2024 by the Court of Learned Civil Judge Junior Division number 2, Golaghat,
staying the execution of the title suit number 8/2022 till delivery of the judgment and decree in title suit number 6 and title suit number 7, 2022. My lord, this suit, my lord, which I filed, my lord, against this respondent number 1, Rupa Gupta,
No, that suit has already been decreed.
decreed, my lord.
Then where is the question of staying that proceeding?
My lord, that, my lord, when the suit was decreed, my lord, then I filed
no,
an execution application.
No, you tell me,
Yes.
the trial court, no, executing court has stated execution case number 2 of 2024
Yes, yes.
or the title suit number 8 of 2024.
Well, I have written, my lord, execution of the judgment and decree passed in title suit number 8/2002.
But can such a meaning can be deciphered from this from this sentence?
My lord, I have written, my lord, impugn order dated 24/1/2025. This is the impugn order passed in title execution number 2/2024.
No,
Staying
you
the execution of title execution, title suit number 8/2022.
where is that order, impugn order?
Impugn order at page annexer 12, my lord. It starts from page 62. May I read, my lord?
Eight of 2022. 8 of 2022 till disposal of the title suit number 6 of 2022 and title suit number 7 of 2022. On the ground that the schedule of title suit number 6 of 2022 and 7 of 2022 and of title suit number 8 of 2022 are same. But the plaint of title suit number 6 of 2022 and 7 of 2022 has not been placed on record. Accordingly, Mr. Dotko submits that he may be granted some time to bring the plaint of title suit number 6 of 2022 and 7 of 2022 before this court by filing an affidavit. There is accordingly allowed. This the matter on
28 April.
28 April.
Item number 6.
May it please the Lordship. Lordship, the petitioner is the principal defendant in the title suit number 706 of 2021, pending before the learned Civil Judge Unit Division 4 in Kasar, Lordship. Lordship, in the suit, Lordship, he appeared, but he could not file the written statement on time. Therefore, he filed written statement with a condemnation petition, Lordship. And
When you had received the notice from the court, someone from the court.
notice I appeared before the court on 16/8.
So when you have received the notice,
Lordship, before receipt notice, Lordship, I appeared. That was
Without
recorded,
receiving notice, you appear.
yes, Lordship, because
Then
I,
how can you come to know about the pendency of the case?
I, after registration of the case, Lordship,
Hmm.
I got to know that case has been filed and that part is already recorded, Lordship, on in the order of 16/8, Lordship.
And when you have appeared before the court,
16/8, Lordship, at page 25, the order sheet I have all given, Lordship. That
I am asking you the date on which you have appeared before the court,
16/8/2022, Lordship.
16/8. And when you have filed a petition,
I have filed petition on Lordship 10/7, Lordship, 10/7/2023. And I filed a WS on 19/6.
no, you appeared on 16/8/2024.
Yes, Lordship.
Then filed petition on
Filed petition on, thereafter I filed petition on 2/11 and 2012, 2012/22. Lordship, that 2012/22, my prayer was not,
you filed petition on the 2nd of November.
2nd of November
2024.
and 20th December.
28th December.
And on 20th December, my prayer was rejected, Lordship, and
So
suit
you
was
file application on which date?
2012, 2022, Lordship.
Then this petition was dismissed on
That was dismissed, Lordship, and thereafter a suit was proceeded for experted evidence against the defendant, Lordship. And thereafter, Lordship, I filed my application for condonation of delay and as well as the vacating of ex parte order, Lordship,
on which date?
on 10/7/2023, Lordship. And in the meantime, Lordship, I filed my WS on 19 June 2023, Lordship. Lordship, thereafter, the learned trial court has clubbed this, my two petition and a miscase was registered, 131 of 2023.
Hmm.
And that was finally decided on 18/12/2024, Lordship. That at page 56, Lordship. Start
So
from
your
56.
petition is was numbered as
Miscase number 131, 2023. Both of my petitions,
what is the number of the petition?
one is, Lordship, 36, petition number 36/7. That is, Lordship, vacation of ex parte order. And another is, Lordship, petition number 1096/69. That is condonation of delay petition, Lordship. Both the petition was filed, Lordship, on 10/7/2023, Lordship. Lordship, as because I was not available here, because I am the principal defendant, Lordship. I am the principal defendant. I was not available here, Lordship. I went to Lordship pilgrimage tour, and therefore I came in the month of December, and I fell ill, Lordship. I produced all the documents before the learned trial court, but that was not considered, Lordship.
You have gone for pilgrimage.
Yes, Lordship.
Is that a justified ground for condonation of the delay?
And therefore I fell ill, Lordship. That's why I could not file my WS in time, Lordship. Lordship, I filed my WS after delay of 217 days, Lordship. Lordship,
Whether the petition is part of the record,
yes, Lordship.
page number.
Page number, Lordship, 45.
In which paragraph you have mentioned the method?
At page 45, Lordship, that the paragraph 2, Lordship, that the petitioner went to religious pilgrimage in the month of October and at Vrindavan, Kashi, and returned home in the month of December 2022. On his arrival from the pilgrimage, the defendant fell ill, and as such, due to the physical illness and ailment, the petitioner could not submit his written statement within the time of limitation, Lordship.
Have you enclosed any medical document to?
Lordship, medical documents were submitted, but I was not supplied by in the record that is there in the petition enclosure. Medical documents and prescription of the petition was enclosed, Lordship. In this petition, Lordship, that was not there. Those documents,
So is
Lordship.
it with you?
Lordship?
Is it with you?
No, those documents would not meet, Lordship.
So unless we see the documents, how can we arrive at a conclusion that you have sufficiently explained the delay?
Lordship, I may be allowed some time to file additional affidavit, Lordship, to enclose those medical
But the
documents.
next date is fixed.
Next date fixed on 29th of April, Lordship, for evidence. Lordship, the plaintiff, even till date, they have not filed evidence also,
Not fine.
not filed, Lordship.
Then immediately after reopening, you file a affidavit
Yes, Lordship.
and bring on record those medical. Pardon, sir.
As to the Lordship.
That's the prop. Or
Dhar.
learn it notes for the. So Suprata submits that he may be granted some time to bring on record the medical documents filed by the petitioner herein along with petition number 1096 stroke 69 to substantiate the ground that he was suffering from ailment at the relevant point of time for which he could not file the written statement within the stipulated period. There is accordingly allowed later at around 23rd April.
Obliged, Lordship.
Pending item 1.
May it please your lordship. Lordship, this is a regular bail application and the earlier bail application was rejected by this honorable court.
But what is this the trial is pending?
Lordship, now the
This is-
charges have been framed. And earlier, my lord, when the bail application was rejected, the charges were not framed. And my lord, arising out of the same case, my lord, the same FIR, there's another co-accused which the lordship had earlier rejected by the same order, my lord, where my bail application was also rejected. This is the order of that matter, my lord, whereby lordship had directed the same matter to be listed together along with a quashing application that the co-accused had filed, my lord. And those matters are listed tomorrow before a coordinate bench, my lord. So I leave it to lordship's wisdom, my lord. Lordship may be pleased to either call for the LCR in my matter or may either be pleased to, my lord, fix the matters tomorrow because
Where the
My lord,
matter is pending?
My lord, no, those cases were
for
listed
crossing the
before court
search.
number 11, my lord.
my,
Causing the order framing of search.
not me, my lord. There are 4 accused persons in the instant matter, my lord. So another co-accused, my lord, whose bail was also rejected by lordship by the same order, my lord.
Hmm.
That co-accused has filed a, my lord, revision against the order of framing
search.
charge and has also, my lord, parallelly filed a bail application. So lordship's order is clear, my lord, with that, in that regard, that those matters be listed together. So those matters are listed together and those matters have come up before consideration, my lord, tomorrow before court number 11, my lord.
But my lord, that case also rejected by your lordship bail.
That
And
that
thi-
was also rejected, my lord.
This case also rejected by your lordship. Then both the matter came before this court, my lord, and my lord, because both the cases bail petition were rejected by your lordship, my lord. In that case,
That roster,
we will mention in that tomorrow we will mention before court number 11 because that case was bail rejected by your lordship. We will mention. That may be fixed and in this case, elsewhere may be call for up to date fixing immediately after vacation, and tomorrow we will mention that case also, my
and
lord,
what
because
is the ground for filing this second bail application?
Second bail application, even though lordship's instruction is there, my lord, that the bail may be considered only after the examination of PW 1 and 2, my lord. Lordship has addressed an issue with regard to the arrest of the accused person in other matters, my lord. Supreme Court as well as your lordship as well as other coordinate benches. That, my lord, the notice under section 47 and 48 was not served upon the accused person.
So that is the ground here.
That is the ground, my lord. And it's not that the grounds of arrest were not mentioned to me. It is that just because I was shown arrested, my lord, because lordship, this accused person who is before your lordship today, he was arrested in a CBI case, which was originally Dibrugarh PS case, which was subsequently transferred to the CBI. While I was in custody in that matter, I was arrested in the instant case, which is before your lordship today,
Borbora PH.
which is Borbora PS case. And in the Borbora PS case, when I was arrested, my lord, then I was not served the notice under section 47 of the BNSS. And my lord, the Honorable Apex Court, as well as my lord, lordship, as well as other benches have held that the notice under section 47 is mandatory. Now, the question which we need to address, my lord, is that whether when an accused person is being shown arrested, I'm already in custody in another case. While I'm shown arrested, whether the notice under 47 is mandatory. And that issue, my lord, the Honorable Apex Court, as well as coordinate benches of this court has held that if I may be arrested in 10 numbers of cases earlier, if I am arrested in the 11th case, my lord, that right of mine under section to be notified of the grounds of arrest and to be served the notice under section 47, that stays, my lord. So on that technical aspect, my lord, that my arrest was illegal and irregular, I filed this instant bail application, my lord. That is a matter of record.
Being tomorrow is the last day, my lord, and before vacation. My lord may fix immediately after vacation, and record may be called for. And tomorrow, as that case also rejected by your lordship, before that court, tomorrow we will mention that matter, my lord.
Or alternatively, my lord, my matter may also be fixed tomorrow, my lord, and a call may be taken, my lord, accordingly.
Because when a matter already rejected by one court,
Mr. Vaidya,
My lord.
to address the issues raised in this petition, we have to go through the record.
Yes, my lord.
We have to go through the case diary.
yes,
So that case diary is not available
Not
before this
available.
court now.
My lord.
So we have to call for it. Because unless the PP goes through the case diary, he cannot say that whether section 47 is complied with. or not.
Comply with or not, my lord.
So let the record come.
let the
I leave it
record
to
come.
lordship's wisdom, my lord. Whatever lordship deems fit.
Heard Mr. Vaidya, Lord, I come for the accused and also heard Mr. Orasur, Lord, additional PP for the status complaint. This application under section 483(1) of the BNSS 2023 is referred by accused. Vishal Pokon, who has been languishing in jail in connection with Dibrugarh PS case number
No, this is Borbora.
This is
Station
Borbora.
case number 350 of 2024, arising out of Borbora PS case number 85 of 2024. Under section 61, certificate 2, stroke 238, 360, we can figure 5, stroke 318, 4 of BNS. Read with section 21(1), 21(2), 21(3), 23 of the banning of unregulated deposits in Act 2000. The learned counsel for the accused submits that this is the second bail application. And after rejection of the first application by this court on when it was rejected
17 to 25 months.
on
Is it
7
Page number
to
88, Lordship's order
2025.
is there.
The learned trial court has framed charge against the present accused. But this present application is preferred on the ground that the provision of section 47 of PNS,
47 as well as 48, my lord, of
47
BNS.
and 48 of PNS were not complied with while causing arrest of the present accused. To appreciate the submission of Mr. Boito, learned counsel for the accused, perusal of the case diary is found to be necessary and accordingly it is provided that Mr. Forrester, learned additional PP shall produce the scanned copy of the case
No,
diary. along with
registry,
the
madam.
record.
Register.
Registry. Registry shall call for the scanned copy of the record
Along with case.
along with the
Along
case
with-
diary report is court on
Immediately on opening, my lord.
23rd. 23rd.
23rd.
My lord.
Admission item 7.
Deeply obliged.
Shortened matter.
May it please your lordship. Lordship, in this matter, I prefer some accommodation, lordship, because the government is verifying that lordship, that annexure 9, that the report which was submitted by the DC regarding the retrospective benefit of those grade 4 staffs. So these matters they are verifying as to the subsequent development. So lordship may fix after 2 weeks, lordship, We'll
After
have
2
some-
weeks, okay.
concrete instruction.
Heard Mr. Islam, learned counsel for the petitioner, and also heard Mr. Sarma, learned standing counsel for the respondent in elementary education department. Mr. Sarma submits that the respondent authorities are verifying the matter and they need some time and
Lot.
press for listing the matter after 2 weeks. There is allowed, press to list the matter on
7.
7th of May.
Lordship.
7.
Problem.
All right.
Item 8. Shortened matter.
Okay, here the finance has given the approval. Now the secretary has directed the director to proceed with the matter and in the meantime, the director has sought a non-royal certificate from the district lordship. So on my telephonic instruction with the inspector of school, right, just for lordship, they said that he has already sent this man to the treasury office. So it will take 1 or 2 days to find out the records and prepare the non-royal certificate. So let it come after vacation, lordship. If it's
Vacation.
progressing, it will be done lordship, in the positive note. Finance has already given that approval. Yes.
Okay.
My lord, kindly see page 17, my non-royal certificate, my lord.
No, it is an earlier lawsuit. Now, as per the section of the finance lawsuit approval, so we have to draw out a new non-royal certificate. Approval is given.
Okay, immediately after reopening.
Yes, yes. My lord, everything is on positive direction lawsuit. Nothing to worry lawsuit. It will be done.
Okay.
Lawsuit may kindly list after vacation.
Immediately after vacation.
Heard Mr. Aditya, learned counsel for the official and also heard Mr. learned standing counsel for the elementary education department. And Mr. Yesalia, learned standing counsel for the finance department. Mr. Solia has produced one letter written by the undersecretary to the Governor of Assam Finance at EC3 department. Written to the address to him, wherein it is stated that financial sanction has already been made. And one non-royal certificate is required from the Treasury Office of
No.
Treasury Office of Nagaon. And as soon as the non-royal certificate is received, then the amount will be
The
dispersed.
necessary process will be initiated. We have to give that sanction and we have to go to the finance again, lordships.
And then the process will be initiated, and everything is in right direction. And press for listing the matter immediately after reopening. Reopening of petition. Here is accordingly allowed. This is a list the matter. Okay.
It may be fixed, my lord. When
The letter produced by Mr. Solia shall be part of the record.
Date,
Obliged.
second May.
ঠিকে আছে হ'ব আপোনাৰ আহিব হৈ যাব ইমান
Okay.
Item
Alright.
9.
May I please, lordship? The present appellant is the owner with respect to 3 kathas of land. So respondent, present
This is
appellant
money
here,
suit.
it's a money suit. This is a suit for, actually, the suit was defective, lordship, as because,
No, you see the heading of the judgment.
yes,
Money suit
that was,
number 6
that was a
of
money suit.
2021.
Yes, that was, what happened, lordship? The present appellant is the owner with respect to 3 kathas of land. And he entered into an agreement for sale dated 19/8/2009 with the respondents first. So alleging non-performance of the agreement for sale, the present respondents has filed the money suit without a decree for rescission of contractors. So my
So
husband,
the suit was decreed.
yes, suit was decreed. With a
What is the
direction,
decretal amount?
10 lakhs, lords.
10 lakh.
10 lakhs. lords.
Okay, we admit it now.
So there is an application under order 41 rule 5. lords.
But to grant stay, you have to deposit security.
25% of the decretal amount is because the fact is that the wife of the present appellant, who was arraigned as the defendant number 2, owing to her illness, the present appellant was compelled to agree to sell the plot of land. But unfortunately, in the year 2011 to 21, during pendency of the suit, she died, lordship. The present appellant, who are the legal heirs of the wife, that is the defendant number 2 in the title suit, they are minors, they are pursuing their studies, lordship. So considering the financial hardship of the appellant, 25% of the decretal amount will be directed to the deposit as a condition for staying the operation of the decree.
Pardon, sir, our server learned counsel for the appellant.
Lordship, execution case number already filed, that has not been brought, as because after filing the appeal, the execution case number 2/25.
This appeal under section 96 of the Code of Civil Procedure is directed against the judgment and decree dated 25/11/2024, passed by the learned Civil Judge Senior Division Gulagat in Constitution number 6 of 2021. Noted here that by decree judgment and decree dated so and so. The learned Civil Judge Senior Division Gulagat in Constitution number 6 of 2021. Has decreed the suit for recovery of a sum of rupees 10 lakhs from the appellant sharing with interest at the rate of 6% per annum from 7/8/2019 till the date of realization. There is a memo of appeal and the grounds mentioned therein. Also, there is the interim judgment and decree dated so and so. admit issue notice to the respondent to return the claim for which the bid taken by respectful with ADM will to play with the process within a week of today. Justice will call for record from the learned trial court. This is the matter after 4 weeks. Hardness of formal or notes for the applicant is interlocutory application under order 41 rule 5. Dated section 151 of the Code of Civil Procedure is prepared by the applicant for staying execution of the judgment and decree dated 25/11/2024 passed by the learned civil of the senior division to litigation number 6 of 2021. Is to be notated by the judgment and decree dated 7. So, what is provided in the,
Order 41 rule.
yes,
Security loss, only
the
security.
security, what is the percentage?
Percentage is not mentioned, Lords. Order 41 rule 5 is silent regarding percentage, Lords.
What is the ground you have assigned for staying the decree?
Lordship, that is not specifically assigned, Lords.
Not specific. Then there is one provision in the new, no, in the NIA. Okay, NIA.
And I act.
See,
Lordship, I have complied order 41 rule 5(3), Lordship.
what is the ground?
There must be a statement to the effect that in the event of not staying the operation of the judgment, substantial loss would be caused to the appellant also. That is provided in order of Fortran Rule 5.3 Lords. That statement is there in the petition under order of Fortran Rule. 25% of
In
the
your petition, which paragraph you have stated?
paragraph number 5 Lords.
So Sharma learned counsel for the petitioner submits, applicant submits that against the aforementioned judgment and decree, an appeal has been prepared by the applicant hearing, and the said appeal is admitted for hearing, and notice has been issued to the respondents. And there is a requirement for staying the operation of staying the execution of the judgment and decree dated 25/10/2024, and the opposite party hearing has already instituted one execution proceeding, being execution case number
Our Lordship. 2/2025.
2/2025, wherein notice was issued in that case.
Yes, Lordship. I had appeared and the date was, last date was fixed on 8/4/2025.
And the aforementioned proceeding notice has already been issued to the applicant hearing. And he has assigned sufficient, he has assigned ground for staying the judgment and decree in paragraph number 5 of the application. As substantial loss would be caused to the applicant hearing unless the impugned judgment and decree is stayed. Further, Mr. Sharma submits that he will deposit 25% of the decreed amount before the learned executing court,
Lordship.
before the learned executing court.
Executive Civil Judge Senior Division, Gulagat, executing.
The senior division Gulagat. Within a period of
6 weeks. Lordship.
no 4 weeks. Within a period of 4 weeks from today. Further, having heard the submission of Mr. Sharma, learned counsel for the applicant, I have carefully gone through the petition and the documents placed on record, and also urged the impugned judgment and decree dated 25/11/2024. And the statement and affirmation made in paragraph number 5 of the application. Since the appeal has already been admitted for hearing, and since the applicant is willing to deposit 25% of the decreed amount as security, and since sufficient ground has been assigned for staying the operation of the impugned judgment and decree, this court is inclined to allow this application. The impugned judgment and decree dated 25/11/2024 stands state till next date, subject however to a sum of rupees to 25% of the decreed amount being deposited before the learned executing court within a period of 4 weeks from today. In terms of this,
Item,
okay, within 4 weeks, you deposit the amount.
Lordship, 25%, that is 2,50,000, that may be specified, Lordship.
Yes,
25%, that is 2,50,000.
decreed amount,
Yes, Lordship.
yes.
Much.
item. 11.
May I please repeat?
Hmm.
Appeal for enhancement lordship.
Hmm.
Lordship judgment and award dated 4/10/24, page 9, lordship.
Art means
J. Akhtar.
they after learned counsel for the appellant. This appeal under section 173 Bracket 1 MB Act. It's directed against the judgment and award dated 4/10/2024 passed by the learned member motor accident claim tribunal Boingao in MSC case number 188 of 2021. Is to be noted here that by the impugned judgment and decree dated so the learned tribunal is directed the respondent opposite party in respondent number 1, the New India Assurance Company Limited to pay the sum of rupees 61,99,440 rupees. Bring the compensation to the appellant hearing. Is it death case or injury case?
Injury lordship.
Injury. In injury case, how funeral consortium is awarded?
Sorry, lordship.
Huh?
Lordship, sorry.
You have not come through the record. Directed to. With interest at the rate of 4% per annum from the date of filing evidence of the claimant, that is 14/7/2023 till the date of realization. Per the memo available and the ground mentioned. Also per the impugned judgment and award dated for. Admit issue notice to the respondent returnable for instance be taken by research area also by the process. Process will call for the record from the learned tribunal. This is the matter of our forex.
Obliged.
12.
May it please your lordship. Your lordship, this is an appeal filed by the insurance company, your lordship, mainly denying the liability, your lordship. In this case, this is was the owner of the vehicle, your lordship. So he is not a third party. It is a settled position of law, your lordship.
Why you are denying your liability?
In this case, your lordship, deceased was the owner of the vehicle insured by us, your lordship, and the owner is not a third party. As such, he is not entitled for any compensation under the Motor Vehicle Act, your lordship. That is the main ground of appeal.
Art means Portaco, learned counsel for the appellant. This appeal under section 173 MB Act is directed against the judgment and award dated 28/1/2025. Passed by the learned member Motor Accident Claim Tribunal, Valpara in MSC case number 0307 of 2019. Filed under section 166 of the MD Act 1998. Is to be notified by the judgment and award dated so the learned tribunal has directed the appellant hearing to pay the sum of rupees. What is the amount?
17 lakhs 51,098.
17,51,098 rupees. Bring the compensation to the claimant. And to the respondents herein with interest at the rate of 7% per annum. From the date of filing the claim petition, that is 17/8/2019. Where is the memo of appeal and the ground mentioned there? And also where is the interim judgment and award dated so and so. Admit issue notice to the respondents returnable for it that be taken by registered also with AD and also by the process. Registrar shall call for the record from the learned tribunal. This is a matter of the 4 weeks.
There is an I for stay, your lordship. Your lordship, I pray that since we are denying liability, we may be. Your lordship,
50%.
we cannot deposit any amount at this stage, your lordship, since we are denying liability, your lordship. So I pray that we may be exempted till the next date, your lordship.
No. You deposit 50%. Only then we will stay.
Lordship, then I'm not pressing the stay at this moment, your lordship. Let them appear. Notices are to be issued, your lordship.
I then issue notice in I.
Obliged, your lordship.
Item 13.
May this is a lordship, in this.
There is delay.
No, lordship, it is for admission. Lordship, again, this is a case of pay and recovery, lordship. We are challenging that judgment. The court came to a clear finding that there was violation of policy condition and still directed the insurance company to pay, lordship. And we are also challenging interest and also the quantum, because all the bills and vouchers did not have corresponding prescriptions, lordship.
When the judgment was pronounced?
16/5/24.
Then what is the period of limitation?
16/5/24. No, lordship, it was, I think, filed within time. It was filed on 14/8/24.
14?
8/24.
Why it was not listed since then?
I do not know, lordship. Lordship will find the filing date. We have also signed, and the filing date will be in the memo of appeal, lordship.
No, that's why having seen the date of judgment, I
Yes,
that it
lordship, that is
uh,
correct. But we filed it within time. Some cases,
Third
lordship, even though we file,
learned counsel for the appellant. This appeal under section 173 of the MPA directed against the judgment and award dated 16/5/2024. Passed by the learned member, Motor Accident Claim Tribunal, Amendment, in MSC case number 121 of 2019. This reiterated by the interim judgment and award dated to the learned tribunal as directed the appellant herein. Pay a sum of rupees. What is the amount?
2,43,233.
233 rupees with interest. At the rate of rupees 9% per annum.
Yes, 9% per annum.
From the date of award or date of filing claim petition.
From the date of filing of the application till the date of payment of the compensation.
The date of filing the claim petition till the date of payment. Where is the memo of appeal and the grounds mentioned therein? Then also where is the judgment and award date and so and so. That notice be admit issue notice to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. Registrar shall call for the record from the learned tribunal. Place the matter after 4 weeks.
I-1182 of 25.
So you want to deposit entire amount?
No, lordship, no, because we are
50%.
not liable, 50%. I love that.
My lord, in this case, my lord, your lordship will find, my lord, at page 10.
Before coming to the
Substantial question of law.
I prefer passing of the matter for right now. And this consider on next lordship. Can it even at 2 p.m. lordship?
At
My lord,
let his counsel come.
He's on next lordship. Pass on for the paper. Pass on.
Item 15.
May I please your lordship? My lord, here in this case, peculiar case, my lord, the appellant as attorney of his mother filed title suit for eviction of the respondent number 1 from the suit premises on the ground of defaulter. This is under Assam Urban Areas Rent Control Act. During pendency of this suit, mother died, so all the legal heirs were substituted, including the pro forma respondent herein. And appearing in this suit, my lord, the bank authority filed an application. Kindly see that application at page 17. The suit is pending on petition of the attorney of the plaintiff, Shefali Debroy, following death of the plaintiff. In the meantime, the 4 daughters of the original owner, late so-and-so, during his lifetime, executed will in favor of his 4 daughters with life estate of his wife of so-and-so. The daughters have obtained probate of the will executed by so-and-so on the death of Shefali Debroy, son of so-and-so, son and attorney of Shefali Debroy, have come up with a will executed by Srimati Shefali Debroy, though as per will executed by the original owner, late Dinobandhu Debroy, is the widow so-and-so, has only life estate and no power to dispose of the property. It appears that the original beneficiaries' daughters are the real owners of the property and rent accrued are payable to them. But in view of the pending suit, defendant bank is not in a position to take any decision in the matter. Moreover, defendant bank have decided to vacate the premises. As such, an order from this honorable court is required to whom the area rent is to be paid and the premises to hand over. Now, this on the basis of this application, trial court decreed the suit like this, my lord. Kindly see at page, next page, and decree is at operative part is at page from 22. Kindly see. It is decreed like on admission order 12 rule 6. And when it was decreed, judgment on admission, then it can be skipped. Thereafter, page 23, it may be noted that in order to enable the court to exercise its discretion, the admission has to be clear, unambiguous, and unconditional. The defendant bank is ready to vacate the suit premises and to pay the area rent. The plaintiff in the present suit has prayed for eviction of the defendant and to recover the area rent. Hence, it can be safely held that the defendant bank has admitted the claim of the plaintiff, but bank is unable to decide the possession of the suit premises and area to the paid. In that view of the matter, I am clearly of the opinion that plaintiff is entitled to a decree. After the above discussion, it has been established that the 4 daughters of the original testator is entitled to get the property after the death of the original plaintiff. Hence, the defendant is directed to hand over the suit premises and area rent in favor of the 4 daughters of the original testator of the will. Now it has been decided like this, that only the 4 daughters are entitled with respect to the suit property, and the appellant is not entitled. And I preferred appeal. Title appellate court came to another aspect, it says that I am entitled for area rent and they are entitled for possession. Kindly see, my lord, at page 50. Appellate order. In the suit, the appeal filed by the appellant, plaintiff number 1, here is the appellant, has got merit, and as such, the instant appeal stands allowed partly on contest with cost. The suit of the plaintiff appellant is decreed partly, and the plaintiff appellant is held entitled to relief as follows. Plaintiff appellant Ranjit Devray is entitled to claim title over the area rent only, that the principal defendants bank are directed to make payment of area rent to the appellant plaintiff, namely so and so. It is further directed to the principal defendant bank to vacate the suit premises forthwith and hand over the possession of the suit premises to 4 daughters of the original plaintiff of the suit within the period of 2 months from the date of passing of the judgment. Wherefrom it has come to conclusion, there is a will, there is a splitting up tenancy. How can it comes in the suit for in a suit under Assam Urban Areas Rent Control Act, splitting up of tenancy? It is nothing but a splitting up of tenancy. Said I am entitled for area rent, they are entitled for possession. So under such circumstances, I filed this second appeal, my lord. Page 6, kindly see the substantial question of law. No trial, nothing. No evidence.
So, Mr. Bose, again, same mistake. You have filed a substantial question of law separately.
At page
It
6,
is not part of the
part
memo
of the memo of appeal, my lord. Page 6, my lord.
No, it is only after the certificate.
Uh,
It is a question must be incorporated in the memo of appeal.
My lord, in the memo of appeals also same question. I have same ground I have
Okay.
given. Same ground with the same
Grounds and suggested question are different.
no, kindly see the page number 4.
No, this grounds cannot be treated as a substantial question of law. You go through the subsection 3 to section 100.
My lord,
There is a decision of Supreme Court. I can give you the citation where it is clearly stated that this substantial question of law shall be briefly stated in the memo of appeal.
that is, my lord, my memo of appeals contains the substantial question of law also, my lord.
So these are
And
the grounds you have mentioned it as.
in the ground as well as in separately, I have mentioned same things as I have.
Subsection 3 appears to be not complied with.
My lord, kindly see order 43.
Subsection 3.
Order 43, rule 1.
No, you filed this appeal under section 100.
No, I am coming. Order 43, rule 1.
No, I am not referring to that provision. I am referring to subsection 3 to section 100.
I am coming. Prior to that, what is the form of the appeal? That is, I am coming, my lord. Order 43, rule 1, kindly see.
No, you come to section 100 first.
Yes. Procedure, I am reading order 43. Why I am reading? Appeal from appellate decree. Procedure, the rule of order 41 shall apply so far as may be to the appeal from appellate decree. This is the form. And now can we see order
Let us
41?
do one thing. I am furnishing the decision of Supreme Court. You go through it, then thereafter I will hear you. I will give you after some time.
Yes. Lord, kindly see my memo of appeal, my lord. In the memo of
No,
appeal,
no, I will not go through it. You either amend the memo of appeal
my
or
lord, my lord,
rest you release the matter before another bench.
my lord, kindly see the
No.
memo of appeal, my lord, kindly
Sorry,
see.
sorry.
My ground number C is my substantial
Sorry,
question of
next
law.
item.
Item number 15 for orders, partner matter.
The Lordship has concluded the hearing, in fact, both sides. Other side also argued the case. But he wanted to file some written objection. The Lordship wanted that if he so files, it can be filed by today. But now,
Lordship, the problem that I in that particular counsel was assisting your lordship that they have to leave for some emergency, your lordship. So otherwise, lordship, the matter may be taken up after some time, your lordship. My senior will appear in this matter.
When?
My senior, after some time, your lordship. My senior will appear in this matter. Mr. Chaudhary will appear in this matter.
So
Lordship,
whether
take it as
you
part
have
of your lordship.
placed on record all those documents
If lordship-
mentioned on the other day?
Lordship, the problem arises with regard to that, your lordship. Because lordship, we had prayed that that the LCR may be called for your lordship. But in the order, it was not reflected that the LCR shall be called for lordship. There was some
No,
difficulty.
we have not called for the LCR.
Lordship, that is the
So on the other day, he assured that he will bring on record those documents by filing an affidavit.
lordship.
Where is that affidavit?
Lordship, we have not filed it yet, your lordship. That particular council had to leave for some emergency today, your lordship. Yeah, but the matter be taken after some time, your lordship.
well, let the
Okay, after some time then,
Lord.
let his senior come.
yes, yes.
Item 18.
Yeah, please, your lordship. Lordship, as per the office note dated 8/4/25, the scanned copy of the LCR is received, lordship. And service was also complete upon the respondents.
The original FIR, original LCR was not called for.
No, Lord. Scan copy.
But this is an appeal.
Lordship.
This is an appeal. Without the original record, would it be possible to hear the matter?
Lordship, may call for the original LCR, Lord.
Scan copy. So you have taken a step without furnishing those stamps. For
Lordship,
which
we will take it by tomorrow.
the steps were returned from the dispatch section.
Lordship, we will take it by tomorrow. The deficit stamp.
Heard miss, your good name,
A
please?
Lala, Lordship, on
Pardon?
behalf of B Chakravarti.
Pardon?
A Lala, on
Learned
behalf of B
counsel appearing
Chakravarti.
on behalf of Mr.
B Chakravarti.
Chakravarti, learned counsel for the appellate. Office note dated 8/4/2025. indicates that scanned copy of the record has been received through email. But it appears that this appeal is preferred against the order dated to the 2nd of March 2024 passed by the learned civil judge, senior division Kasar in the case number 13 of the arising out of PS number 06 of 24. So against the order passed in Mizze case.
Yes.
Where is the impugn order? This number?
Page number 73 to 82, Lordship. Order dated 2/3/24.
Okay. Side office note also indicates that notice issued to the respondents by post. Issued upon respondent number 4 to 11 could not be sent due to shortage of stamp. And the same was returned to the dispatch section. Further, the office note indicates that notice issued through usual process upon respondent number 5 returned not returned till then. And in respect of respondent number 6, the notice was issued by received by mother. And in respect of respondent number 7, the he refused to accept the notice for which the processor were hung the notice in front of the door of his house. And in respect of respondent number 8, 9, 10, and 11, the same were received by an employee of the respondent firm. Accordingly, it is provided that the learned counsel for the appellant shall take special step upon respondent number 1, 1 to 4, 5, 1 to 4, and 1 to 5. 1 to 5. By registered post with AD and also by usual process within a week from today, at least the matter after 4 weeks.
Pending item 17.
My lord, the term of the body is till 15th of May. We were thinking of filing a short rejoinder, we could not do it. Your lordships can kindly accommodate for on 22nd, Miller.
22nd.
Yes.
My lord, my concern is this matter is there is urgency. This is an injunction matter. And prima facie, lordship has heard this matter for 2 days. And lordship has seen the fact. if at all Lordship is inclined to adjourn it further, because Lordship was hearing it with an intention to decide it. Urgency, considering the urgency. Now, my lord, if Lordship wants that it should be adjourned further, my respectful submission is that there should be an interim order. I pray for the stay of the interim order.
We're just thinking of filing a
Because
short
otherwise
objection.
also, otherwise this adjournment will make my case in practice.
No, till 15th of May,
And
the
this
body
is
is
the
there.
situation.
The cause
No,
of
those-
action is alive till 15th of May. I'm only praying for 21st, I'm not there, and that's why I'm praying for 22nd.
My lord, ultimately, they are getting the advantage of the court's order, as I submitted earlier. So they are taking it and trying to take it to the end. And all these will be infructuous futile.
No, but there are
exercise.
two concurrent findings.
Therefore, my respectful submission is, if at all they want time, Lordship is hard it enough. Lordship.
No, on the other day, we have not opted for granting this interim relief. That's because we decided to hear the entire
Exactly.
matter and to finally dispose of the petition.
Yes.
And that was done.
Yes.
2 days, Lordship heard it.
No, they want to file objection.
They wanted
Short
to file
objection, my lord.
objection, but they
Only thing is, my lord, but for the intervening holidays, otherwise matter could have been taken up on Monday. That's why I'm saying. But for the intervening holiday,
that is why Lordship fixed it today, because of the intervening holidays. We wanted to get it done today itself, before vacation. And considering the prayer of the made by my learned friends, junior friend, Lordship ultimately.
in fact, my
granted
lord,
the
my
time.
another handicap is, my lord, today he is also not there. That's why, my lord, this could not be filed. He's out of station, my lord, today, my lord.
But he had argued the case. He has put forward his argument.
Okay, let it be on 22nd.
Yes, ma'am.
22nd.
My lord, my
We'll
prayer
finally
that
dispose of the matter.
Yes.
at least until then, interim order should be there. This should not be given effect.
No, let them file their objection.
Yes.
I never objected to it, but it is not coming forth. And my
No, on
my
22nd,
petition,
if you
my
don't file,
my
lordship will
petition will
consider
be is going to be infructuous.
No. Before that day, we definitely will take it up.
Yes.
22nd.
Lord Mr. KK Molto, Lord Senior
Part of the
Counsel assisted by Mr. R. Gusami and also Ms. N. Begum, Lord of Mr. K. Choduri, Lord Senior Counsel assisted by Mr.
And go to.
Heard in part, is the matter on 22nd. On that day, the respondent opposite party may file their objection, and in the event of failing to file the same on that day, the court will proceed to finally hear and dispose of the matter.
But
Item 19.
Service in respect of respondent number 4, 5, 6, and 7 is completed, my lord. My lord, kindly peruse the order dated 21/3/25. I passed by the Lojima court. As per the article taking report I have submitted, the service in respect of respondent number 4, 5, 6, and 7 is completed. So let this matter may come up for hearing. LCR has been received.
LCR received.
Yes, ma'am.
Oh, 1, 2, 3 already completed.
Yes, ma'am.
Okay. Third Mr. Sunset learning from the appellant. Order of Lausimbang Court dated 21/3/2025 indicates that service upon respondent number 4, 5, 6, and 7 seem to have been completed. Seem to have been completed. Mr. Sunset further submits that since service has already been completed and LCR has also been received and the matter is ready for hearing, and as such the matter may be listed for hearing. Accordingly, it is provided that rest shall list the matter for hearing. In usual course,
No, my lord. The matter is urgent, my lord. After 1 month. my lord.
in the last part of May.
Yes.
29 May.
Yes.
Acha. Is a propon for respondent number 2. 2 and 3. Then Mr. Purposer for 1.
Item number 20.
May it please your lordship. My lord, quite a few missed cases are posted today in connection with second appeal RSA number 128 of 2002, my lord. That appeal got dismissed for default in the year 2012 due to the non-appearance of the counsel. Now, what had happened, my lord? This case was dealt with by learned senior friend C.K. Sharma Barua. But prior to dismissal, he passed away. So at the relevant time, there was no representation. Unfortunately, his junior also had died, some Das Gupta. So, my lord, the case got dismissed in the year 2012. Then, my lord, that was not known to the party, and by the words of mouth of the villagers, when they learned that the appellant has lost his case before this honorable court, they came in the year 2017 and they engaged another senior counsel, Mr. P. Roy. That learned senior counsel filed application under Order 41 Rule 19 along with condonation petition. Then what had happened after issuance of notice during COVID period, that learned senior counsel also passed away. So after issuance of notice, the case remained at standstill. Then in the year 2022-23, the brief in the case, I was engaged in the matter, and I filed a petition under Order 22, Rule 4, because when the condonation petition, notice on condonation petition was issued, a report came that both the respondents had died. So I filed a petition under Order 22, Rule 4. Now, these are the cases, my lord, that 1842 of 17 is under Order 41 Rule 19 for readmission of appeal. Then 1841 of 17 for stay of the impugned order. 1840-17, that is for condonation of delay in filing restoration. But when the report was there that the respondents, both the respondents had died. The former counsel took steps and
That's
filed.
now we have to issue notice. To whom we will issue notice?
My lord, prior to that, I want to make a little submission because by the order dated 19/10/2022 in I civil number 3407 of 2019. This honorable court
Where is the delay
accepted.
petition? First, your
Miller,
delay petition.
delay petition in filing appeal, my lord. Restoration.
Restoration.
Restoration, my lord.
What is the number of the IA?
1840. 1840 of 17.
Now, which petition has to be taken up first?
Yes, a notice was issued, my lord. In this case, my lord, in the year Come order actually. Yes. On 16/11/2018, on condolence prayer, notice was issued.
Okay, but madam, today item number, this IA number 617 is listed.
I number Miller.
617/2024.
617 because the appellant has died. So another petition under order 22 rule 3. That is within time. So for substitution of the heirs of the appellant number 2. 617.
So this application is within time.
What's your honor?
This
My lord,
application is within time.
Yes, it is within time because he passed away on 11 November 2023 and the petition was filed on 1st February 2024.
Where is the certificate? That certificate.
Huh? Death certificate
Not enclosed.
that will not be filed. I have stated on affidavit that I can obtain if your lordship is.
Part means B. So today, learned for the applicant. This interlocutory application under order 42, order 22, rule 3 of the Code of Civil Procedure is preferred by the applicant for substitution of the legal heirs of appellant number 2, namely Ratna Kumar Nath, who suffered demise on which date he died?
He died on 11 November 2023.
11 November 2023. Leaving behind
Heirs.
8 legal heirs. 8 legal heirs. The learned counsel for the applicant submits that as the appellant number 2, Ratna Kumar Nath, suffered demise, the legal heirs of appellant number 2 are required to be impleted in RSA number 128 of 2002. So, is there any requirement for issuance of notice to the respondents?
Yes, in 3407, not in this case. This was, this petition was, no order was passed on this petition.
No, no. Is there any requirement for issuance of notice? In
No,
this
no need, no need, because appellant has died, no need.
Having heard the submission of learned counsel for the applicant, also taking also considering the facts and circumstances of the record. This interlocutory application is then allowed. The names of legal heirs of respondent number 2 is substituted in the RSA number 128 of 2000 in terms of this IA stands disposal. Thereafter, which IA is to be taken?
Then another IA, my lord, that is under order 1 rule 10(2). That IO is 3386 of 2023.
This IA is for what purpose?
What has happened, my lord, in this case, when during the pendency of the appeal before the first appellate court,
This appellant number 1 died.
yes, appellant number 1 died, and when his heirs were substituted, due to inadvertence, one of his class 1 heirs got left out. So in the decree, her name did not get reflected. So I have filed this petition because she is one of the class 1 heirs. Order 1 rule 10, sub rule 2, the daughter of the appellant number 1, during the pendency of the first appeal, she died. But when the substitution was made, her name got left out. So I pray that her name may be incorporated as appellant number 8 in all the IAs, as well as in the memo of appeal. But the
But can we do it in this second appeal stage?
Yeah.
Can we do it in the second appeal stage?
Second appeal?
Yes.
My lord, she is a necessary party, my lord. So this honorable court may please to pass an order for incorporating her name, my lord, because she is a little bit prejudiced, my lord.
No, no, it was passed by the trial court. Then it was affirmed by the first appellate court. Now, can this court sitting in second appeal direct the incorporation of the name of another person?
She is one of the class 1 heirs, my lord, of the appellant before the first appellate court. But since her name did not get substituted, she was a minor at this time, so her name got left out. Now, when she preferred the appeal, I was furnished with a list of the heirs. Then her name I could not find, so I made this application because she is one of the class 1 heirs. If your lordship desires that the knock is required, then I can get it for your lordship's satisfaction, because her name got left out. Her name does not get reflected in the decree, my lord, because she is the daughter.
Therefore, can this court incorporate her name in the decree and array her as a appellant in the second appeal? Art Miss B. Chaudhary, learned counsel for the applicant. This application under Order 1, Rule 10, Bracket 2, read with Section 151 of the Code of Civil Procedure is prepared by the applicant for addition of a party as one more appellant in RSA number 128 of 2002, pending adjudication before this court. Leaves the matter for further deliberation on when you will be able to produce relevant provision. And
Date. Any date, my lord, May, in the month of May.
9th of May.
9th May.
Above judgment.
Okay. 21.
We have filed the objection. Objection is not on record. We have filed the objection. The petition filed by my friend also. That is not on record. We can file it on record.
Not on record. Well, when did you file it?
8th of April.
8th of April.
Immediately after vacation, lots of this matter.
And what is the ground?
Ground is Lordship, as initially there is a GD entry regarding the accident. As per GD entry, unknown vehicle caused the accident. Thereafter, Lordship, information was given for another vehicle after 1 month. So the vehicle was, how the vehicle has located, there is no information. And that is a implant vehicle. As per Supreme Court judgment, Supreme Court has said that FIR file after 1 month from the date of accident is very doubtful case. And owner also given a statement and informed the insurance company that his vehicle was not involved in the accident. And that was brought on record.
Yes, Mr.
The owner did not appear before the court.
No, we have brought on. We have brought on record.
Owner, this vehicle was seized by the police. Ultimately, a case was registered against that vehicle, and thereafter, a case was also going on before the trial court against that vehicle driver of the vehicle, and the MSCT court has the insurance company has adduced him as evidence. Call him to appear before the MSCT court as a witness, but he did not appear. And they said that he made a statement. His statement before whom? Not before the court. And this court has passed this judgment on the basis of the search sheet submitted by the police. And as per the search sheet, that vehicle was involved in that accident. And they have said that the owner made a statement before that.
Mr. Goswami, we will hear the appeal.
Finally, Lordship may dispose this appeal.
No, let them withdraw this 50% amount. They will execute one bond, indemnity bond.
Whole stay, Lordship, there is no deposit.
Pardon?
There is a whole stay by the tribunal, by this honorable court. Award has been stayed fully.
When?
Stay order has been passed by this honorable court. This stay petition also.
There is no difficulty to deposit 50%.
So Lordship have to modify that order. Stay order has been passed on 2/2/2022 in IA Civil 218 of 2022. And they have filed the IA for direction to deposit 50%.
No, here the judgment and award is state.
Lordship, that is why we have preferred the appeal. In one case, Lordship has directed the registry to file an FIR against the Panchan police. In such a case, Lordship, considering the GD entry and everything, this court has passed an order directing to file FIR against the IO. How they have traced out the vehicle, because final report also enclosed, and the final report also how they have traced out the vehicle. Any statement of under section 161 that this vehicle.
No, this is a certified case.
Ultimately got acquittal according to my information.
No, maybe there may be acquittal on different ground.
No, the vehicle involvement of the vehicle must be proof, Lordship. When involvement is denied.
No, whether such a finding is there in the court.
Tribunal has came to a finding against the evidence adduced by the insurance company. Insurance company has adduced evidence that GD entry passed by this recorded at the time of initial accident, and the police report and the FIR and everything has been produced, and the statement of the owner also produced. That has been ignored by the tribunal.
Which order the amount was deposited before this court?
Not deposited, Lordship.
Not
Here in this
deposited.
appeal, no deposit.
No, not deposited.
Lordship. Lordship, immediately after vacation, Lordship will hear the matter finally, I think.
In this case, police has filed the search sheet, my lord, against the vehicle, against the owner cum driver of the vehicle.
No, we will finally hear the matter then, after vacation.
There is no difficulty to deposit 50%.
No, already the judgment is state.
Immediately after vacation.
Part Mr. Kendall, learned counsel for the applicant, and Mr. Tusam for respondent opposite party. Let's this IA along with the MSC appeal number 45 of 2022 on how do you fix on that?
In the month of May, Lordship. On 9th May.
9th May. On that day, an endeavor will be made to finally hear and dispose of both this IA and the
appeal. Apply.
22.
The Lordship will take up the CRP for disposal or
Yes, in the IA, what was the instruction you have received?
Lordship, that was on that day the letter that they have given. It is a letter from to the circle officer about this. The petitioner has no knowledge. So the letter furnished by my learned friend.
Oh, where is the impugned order in the CRP?
Lordship. Before the impugned order, Lordship, impugned order starts from page 87. And relevant Lordship will find in page number 95.
Yes.
Paragraph 11. In the miscase number so and so arising out of title suit number so and so, the petitioner's opposite parties contended that the revenue authorities contemplated to evict them without demarcation of the land in question, hence the learned trial court allowed the injunction as straightforward. However, during the pendency of this appeal on 16/11/2023 and again on 4/12/2023, the respondent authorities, in particular the circle officer Hailakandi Revenue Circle Office, after giving new notice to the parties, caused a survey of the disputed land covered by DAG number so and so from A to Z point. A trace map is also prepared by the revenue authorities, clearly indicating the land covered by DAG number so and so. The said reported forwarded by number so and so dated Hailandi the 9th of February 2024, issued by the Circle Officer Hailandi Revenue Circle, is submitted in original by the learned government leader to this court. Thus, it appears that the directions of the Honorable Guwahati High Court is complied with by the present appellant state authorities by demarcating the land covered by DAG number so and so from its A to Z point. As the reason behind granting injunction is already fulfilled in the manner stated above, the injunction order dated so and so passed by the learned trial court automatically becomes infructuous. Although the learned trial court did not commit any wrong in passing the injunction order impugned herein, in view of compliance of the directives of the Honorable Guwahati High Court, the impugned order stands set aside on its becoming infructuous. Situated thus, the instant appeal stands allowed.
So it become infructuous.
It is the view of the learned appellate court whether an injunction order can become infructuous, Your Lordship. What happened when we have filed the title suit? We have filed a miscase also for injunction. They have filed their response to that case also, Your Lordship. Thereafter, the learned trial court, after hearing both the parties, have passed an injunction order, Your Lordship. Balance of convenience, all the points have been elaborately discussed. Those things were put to challenge before the learned appellate court below. They have taken various grounds, but nowhere they have taken the ground that they have demarcated the land. But at the time of final hearing, they submitted some documents to the learned district just saying that we have already demarcated the land, so the injunction should be set aside. On that ground itself, Your Lordship, when the learned appellate court below was of the view that the learned trial court did not commit any wrong in passing the impugned order, whether he can, Lordship, verify or modify the order on the basis of some documents furnished by them. At best, Your Lordship, they can.
The Reed court has directed to demarcate the land.
Yes, first they have to demarcate the land
And
before
that
going for
demarcation
any
was carried out.
before going for any eviction process.
This was carried out.
Now, that is their case that they have carried out and they have filed some documents, Your Lordship, before the district judge to which we are not part.
Now, whether injunction can be granted against the Reed court, order of Reed court.
No, injunction was not granted against the order of Reed court, Your Lordship. There was a direction from the Reed court. They did not comply with the direction at that time of when we filed the petition, Your Lordship. The learned court below considered the matter and passed an injunction order, Your Lordship. Now, if the things that in the meantime they have already done the thing which was required to be done, they can place it before the trial court, which is in session of the matter, Your Lordship. The matter is pending before the learned trial court. When the appeal was filed, nowhere they have taken the ground that we have already demarcated the land. It was some other legal grounds that the learned
Now
court.
the appeal is pending there.
Appeal disposed of, but the suit is pending.
Disposed of, Lordship.
Suit is pending before the
Suit is
learned
pending before the trial
court below.
Suit was filed after the direction, after
Yes,
the
yes,
date
after
of the
the-
direction,
correct,
Honorable
correct.
High Court.
Correct. Now, Order 39 Rule 4
They came
specific-
before this Honorable High Court. Honorable High Court was directed to demarcate the particular suit of land. And we are complied the honorable direction of the Honorable High Court. Then they came to file the suit.
No. Suit was filed before before they have done the demarcation action. Nothing was done at that time. So we filed a title suit because writ petition was filed because only 4 days time was given for eviction. At that time, we immediately approached the Honorable High Court. The High Court stayed the matter and then heard the matter and then said that no, you cannot carry out the eviction. First, you will have to demarcate the land. The party should know which portion of the office land is you are seeking to evict him. So that was the direction. Then we filed a title suit before the learned court below, Your Lordship, seeking right title and interest. At that time, notice was issued in the main suit also, and we have also filed an IA. The IA was contested by them also. In the miscase, they have filed the written statement. After hearing both the parties, Your Lordship, an order was passed, Your Lordship, granting status quo. Because the title
Status quo, no, Lordship.
injunction, that is injunction, yes, granting injunction, temporary injunction. Now, Your Lordship, if this feels that the basis on which the injunction was granted, that situation has already been overcome, they, at best they can apply an application under Order 39 Rule 4, Your Lordship, before the trial court, which is in session of the matter, Your Lordship. The appellate court was of the view that the large trial court did not commit any mistake. It was absolutely okay. But since they have furnished some documents to the learned appellate court saying that we have already demarcated, so the learned court below was of the view that the injunction has become infructuous. How injunction will become infructuous, Your Lordship? And if they feels that no, they have done certain things which ought to have come to the knowledge of the trial court, they can file an application under Order 39 Rule 4, bringing in those facts that we have already demarcated the land and therefore the injunction order is required to be modified. But the appellate court below, when the court held that there is no any error committed by the learned trial court, he has modified the order, Your Lordship. With all the relevant documents, Your Lordship, let them appear before the trial court and file an application. The trial court will consider the matter and pass. appropriate order. That is what the law provides, your lordship. In appellate stage, your lordship, what are the grounds that they have taken while filing the memo of appeal, lordship will take up. I have annexed that. While the appeal was pending, in between they said that they have carried out the demarcation and they asked the additional district judge that we have carried out demarcation, so the injunction order should go. And they have placed some documents before the learned additional district judge. With the records, let them file appropriate application before the learned trial court, which is in session of the matter. We will contest, and if learned trial court is powerful enough to revoke its own order, if it finds that no, the grounds on which the same was done has been modified, your lordship. In the appellate stage, they did not furnish us any documents. The memo of appeal does not contain what they have stated in the final argument, your lordship. And in the final argument, the learned court below was also saying that no, the trial court was justified in passing the order. But in between, they have submitted some documents to the appellate court saying that we have already carried out the order of the High Court. So the order, injunction order should be set aside. I will take your lordship only to order 39 rule 4, your lordship. That will clarify the whole issue, because injunction order is a very temporary in nature for the time being. It is not a permanent order, but it can be. Order 39 rule 4, order for injunction may be discharged, buried or set aside. That's what the provision provides. Any order for an injunction may be discharged or set aside by the court on application made thereto by any party dissatisfied with such order. Once injunction order goes, your lordship, the trial court will.
Okay, what is your stand here?
Lordship, we have a limited power, lordship. We are only DAG number 349. They are here in this appeal. The instant applicant has stated that about the DAG 49, they don't have any knowledge. But in a read petition before this Honorable High Court, they are stating about the 349 DAG number. Now we are only limitation in the 349 DAG. This particular 349 DAG is a government cast. He is a illegal occupier, illegal encroacher. It is no doubt about it. It is there is no any dispute that over the DAG number 349, the instant applicant is a illegal occupier. There is no doubt about it. And
so the dispute relates to this DAG.
Yes, Lord. Only we are in 349 DAG, Lord. They are stated in several DAG numbers. We are not on that, Lord. We are only 349, as because of it is a government cast. The land in question that the mean for the purpose of the public road, which was connected to the National Highway 154. Now 154, the construction of the National Highway 154, it is narrowed down in this locality, Lord. As because of their enforced a portion of land, lordship. It is now what is happened, lordship. Being the enforcer of the government cast land, is there any right of the petitioner? He is a legal enforcer. He stated that more than 100 years we are in the possession of this land, but no any right title interest there. Is it possible to government cast land at the long time we have possessed illegally, and we have possessed and we have enclosed the government cast land long duration? Is it the right title interest there? No, nothing, lordship. That's why, lordship, our stand is there. It is clear that it should be as soon as earlier it should be vacated, as because of this particular land are reserved for public purpose, public road, which was now connected with the National Highway 154. The National Highway 154.
Is there any stay order operating?
Lordship.
No.
No stay. No stay.
Para 23 of your
High Court order.
Acha. That in the Read Court order.
Read Court order. Para 26 reverting back. Reverting back.
20?
26.
Okay.
Reverting, Lordship got it.
Got it.
Reverting back to the facts of the case in hand, it is already noticed that the petitioner have failed to show by any kind of document that they have any bona fide claim in any part of the land measuring 15 kotas and 12 sotak of land falling under the dock number T49 and Pottanong, second arrest, village Narayanpur part 2. The revenue record go to show that the plot of land covered by dock number T59 and Pottat second arrest second has been recorded as government khas land and the same is reserved for the road. Notwithstanding the claim of the petitioner regarding the possession of any portion of the said plot of land, the petitioner have been found to be in possession of the said plot of land without any kind of permission from the respondent authority. And as such, they cannot be turned in any other or other manner other than encroachers. The allegation against the petitioner are that by encroaching upon the said plot of government land reserved for road, the road is which mean for the general public to communicate has been narrowed down, making it difficult free for movement of the general public who use the road for their day-to-day activity. When the public interest for restoration of the government plot of land reserved for road and for the general public is considered vice versa to the private interest of the petitioner, it is always the public interest which shall prevail, more particularly when the petitioner have failed to make any bona fide claim. So we are doing the as per the settlement rule 18,
okay.
18.2, Lordship. As per direction of the, as per we have complied the direction of this honorable court. That's why we have already demarcated the land in question.
Okay, we will pass the order then.
Lordship.
The thing was done during the appellate stage, Your Lordship. At the time when Lordship will go through the trial court order also, Your Lordship. Elaborate all these issues that they have raised.
Okay,
were
definitely
discussed,
we will go.
Lordship. My prayer is that let them appear before the learned trial court under order 39 rule 4. Filing an application, the application can be modified. Otherwise, the title suit will become infringed.
May it please your lordship. First of all, I apologize, my lord. I beg to mention one by order matter which is listed today as last item, motion item 32, my lord. My senior has got some eye problem. Due to that matter may be adjourned, my lord.
So when to be taken up?
After Bihu, my lord.
After vacation?
Yes, my lord.
Item number?
32.
32.
32, my lord.
The pair being made by Miss
S. Musahari, my lord.
S. Musahari, learned counsel for the petitioner SSL is the matter. After Bihu petition.
Obliged.
Accept.
Finding 14.
That's your lordship. My lord, at page 10, my lord, we have stated, my lord, the substantial question of law. My lord, that is involved in this case.
So here also same thing. This substantial question of law are not part of the memo of appeal. You see the judgment, Kobe. So the judgment of the Supreme Court. And also see subsection 3 to section 100.
I have
And
seen, my
thereafter
lord.
you tell me whether you have complied with it or not.
My lord, it's a part of a memo of
No,
appeal because
it is after the certificate, cannot be considered as part of my memo.
only thing, my lord, yes, after certificate. That is correct, your lordship. That is correct.
Not in compliance with subsection
My
3
lord,
to section 100.
Narayan and Rajendra, my lord, CPL appeal 742. That is the judgment, perhaps your lordship is referring.
Okay.
in other case also, your lordship has pointed out this aspect.
Yes.
Yes. Then I will be allowed to, my lord, amend the memo of appeal.
Mr. Vacation learned.
Because this is the mandate of law, my lord. I will have to follow.
Uh, press for listening the matter immediately after view vacation.
My lord, one aspect of the matter which I would like to point out, my lord, that the other side, my lord, the plaintiff, who are defendant in the suit, they have filed an execution case, my lord. After filing this second appeal. My lord, earlier there was a petition for continuation of delay. So notices went to them, they appeared, then delay condoned. Ultimately, the case is posted for today for admission hearing on order 42 rule 1. Now, this execution case is fixed on 19th of my lord, April before the learned executing court, Bopeta, my lord. Now, if they, my lord, if partly, my lord, to my instruction, my lord, partly the decree has been put into execution, my lord. Now, they are all set to execute the decree, my lord. Now, if my learned friend is appearing before the executing court also, my lord, if they give an undertaking that they will not pursue, my lord, because there are certain, my lord, substantial question of law, my lord, involved in this case.
And that's all right.
Therefore,
Without admitting
that's,
the appeal, we cannot pass any
yes,
order.
that is correct.
Anyway, Mr.
But
Alam.
prima facie,
My lord, this is not actual position of status of before the executive court, my lord. Executive court has fixed the matter, my lord, on 19.5. 19.5 for hearing upon their application, they have filed an judgment letter has filed an application under order 26 rule 9 for appointment of Army Commission. Matter is sub judice thereon. After disposal of their application, the question of execution will arise, my lord. They have approached the executive court by filing application, my lord.
Okay, Mr. Sen, before that day, we will consider your case.
Now, execution case is
So,
fixed on
let
95.
us fix it that in the first week of May.
My lord.
In
My
fact,
lord.
in 1989,
7th of May.
I am deeply obliged, my lord.
May I please, Lordship?
Yes.
Lordship, the senior Mr. Dian Bhattacharya is out of station. And that's why he asked me to take time. And he has informed me.
Okay, as
I was also informed.
Mr. Your good name, please?
B. Kumar. On behalf of
Kumar, Learned Counsel, appearing on behalf of
Dian Bhattacharya.
DN Bhattacharya, Learned Counsel for the applicant, raises a lesser matter on.
Lordship, it was fixed for 9th of May, Lordship. Along with the main CRPIO 54224, it was fixed on 9th of May. Along with this, I may be fixed on that day, Lordship.
Is there any urgency?
Yes,
No.
I was also informed in that manner.
Okay. 24 on
Obliged.
9th.
Obliged.
May please, Your Lordship. Lordship, in CRPIO, while issuing notice, there are some mistake occurred, Lordship, in the impugn order, in the order, Lordship. I have filed one IA for correction of that order, Lordship. CRP. In the CRP, Lordship, the learned trial court granted injunction in favor of the petitioners, Lordship. And the first appellate court directed to maintain status quo, Lordship. Against that, we have filed the CRPIO. So, Lordship, the mistakes occurred in page.
Paragraph number 2.
Yes, Lordship. Paragraph 3, line numbers 1 and 2. Paragraph 3, line number 1 and 2, Lordship, it is to be noted here that while impugned judgment and order dated, it ought to be, Lordship, either impugned, if it remains as impugned, then 3/3/2025. Your Lordship
Okay,
has,
state of this, okay.
there are some more mistakes, Lordship. In paragraph 4, line number 1, it is written as.
No, it was dictated in the open court, perhaps you were present.
Yes, Lordship,
So why don't you point it out at that point of time?
we have pointed out, Lordship, thereafter, Lordship, it remains.
Pardon?
We have pointed out, Lordship. In spite of that, Lordship, some mistakes remain, Lordship. In fact, Lordship, impugn order is 3/3/2025, and the trial court's order is 14/8/2024. I have mentioned in paragraph, Lordship, that is paragraph 3 of my IA. Subparagraph 1, I have mentioned that in paragraph 3, line numbers 1 and 2, it should have been impugned judgment and order dated 3/3/2025, but it has been wrongly typed as impugned judgment and order dated 14/8/2025. And second paragraph, in paragraph 4, line number 1, it is written as void impugned order dated 14/8/2024.
Okay. Heard means our Sodori learned counsel for the applicant. This interlocutory application is deferred by the applicant. For correction of the order dated 21/3/2025. Passed by this court in connected Shirley IO number 103 of 2025. The learned counsel for the applicant pointed out that in the order dated 21/3/2025 in paragraph number 3, the impugned order is mentioned as 14/8/2024, but in fact, the date ought to have been 3/3/2025. And
Paragraph 4, Lord. 14/8/24 is not the impugned order. Impugned order is 3/3/2025.
And in paragraph number 4, the order dated 14/8/2024 is termed as impugned order, but in fact the same has not been impugned order. Accordingly, it is provided that henceforth the order in the date of the order, impugned order in paragraph number 3 shall be read as 3/3/2025. And the word impugned order in paragraph number 4 of the order dated 21/3/2024 shall be deleted. In terms of above this high instance clause.
One more, Lordship, that is page 18, your Lordship, there is mentioned as 3/3/2024.
Page?
But it page 18, Lordship. But it ought to be 3/3/2025, Lordship. March 2025, first appellate court's order, Lordship. This court is inclined to stay the impugned judgment and
Further,
order.
it is provided that in the last paragraph of the aforementioned order, the date shall be read as 3/3/2025 instead of 3/3/2024.
Lordship, I'm deeply obliged. Okay. Earlier, Lordship, interim was directed to be continued till returnable date. Thereafter, we have filed this missed case, Lordship. Obliged. Lordship.
For hearing item 25.
Hold on. He informed me that today the hearing will be done. Now they are saying that he is on leg, Lordship. Mr. MJ Kadir is appearing for respondent.
Yes?
He's on leg.
Oh,
For respondent, Lordship. I'm for the appellant.
So after vacation then.
I'm appealing for respondents 5, 6, 7, and 19. The state of Assam respondents 5, 6, 7, and 19.
Part is particularly learned for the appellant and Mr. Bhattacharya for respondent number 5, 6, 7, and 19. And Madam for respondent number 1 to 4. List the matter immediately after reopening of the petition.
Obliged.
7.
I am for the opposite party, my lord. It is an appeal against concurrent findings.
My lord, we have filed an IA under Order 41, Rule 27, my lord. That has not been tagged today. We had filed it on Monday, my lord.
No, you could have informed this court in the morning.
My lord.
Yes, my lord.
We could have called it from the
Yes.
section.
My lord, nowadays some scanning thing is required. So maybe for that reason it has not been, my lord, tagged.
No, no.
the records.
What prevents you from mentioning the matter in the morning?
My lord, I could not reach on time, my lord.
The learned counsel for the appellant submits said he has filed one IA. But the same has not been tagged with his RSA number 125 of 2022. Accordingly, it is provided that register shall list the matter immediately after reopening of the petition, along with the IA. What is the number?
My lord, it is there in the slip, my lord.
It has not yet been registered.
It has been registered, my lord.
This is filing number only.
Only filing number. Filing number.
And my lord, only submission is, my lord, this is an appeal against concurrent finding and an appeal file, my lord. After, my lord, Order 41, Rule 27A. This appeal come to ends, my lord, when at the time of your final hearing, my lord, if this honorable court deems fit the further additional evidence is required, then this allowing of this type of application required. So I will argue on the next step, my lord.
Let the IA
Yes,
come.
my lord. Yes, my lord.
At the time of
Yes.
hearing, it will be necessary.
My lord, if necessary, in the meantime, I think, my lord, if file objection, if necessary, I'll file in the meantime, my lord. If necessary, otherwise, I will not file any objection in.
Okay.
Deep, lord.
Items 36 and 37.
Just to connect it period, I mean 37, and then it for the owner of the vehicle. My data print is for the insurance company.
I filed 36, yes, filed 37.
So ready to argue the matter?
Yes.
Ready?
Ready.
Other side is claimant is not.
Who is
Claimant. I mean, inform him is coming.
Who?
Ahmed,
May I say Ahmed? Molfaka.
Okay.
No, 30. No, 36, 90.
36, 37.
He's coming. I'm informed.
Coming. Let the council come in.
Item 10.
That's last time.
Make it clear. But, now this is an appeal before your lordship. This was earlier revision which have withdrawn. Now only anxiety, my lord, is your lordship kindly sees the impugned order that is at page 130, in fact, at 139. Now, we filed a suit and an injunction petition under Order 39 Rule 1 and 2, along with the prayer under Order 39 Rule 3 for grant of ad interim injunction, dispensing with the requirement of issuing notice before grant of injunction. Of course, the formalities, your lordship is aware that after the ad interim is granted, we are required to take steps for service of notice and file affidavit within 24 hours. So we made the prayer for ad interim injunction. However, as per this order, at page 139, my lord, the learned court below has just issued notice fixing a date for appearance of the other side, enabling them to come and appear and file objection. Now, my humble contention is the moment they get the notice in this case, they are now under possession of the scheduled suit length. They will immediately and rampantly, they will start changing the nature, feature and character of the land. Even worse, they may even make an attempt to alienate the property, thereby causing a third party right being created here. So my contention before the learned court below was that till they come appear in the injunction petition, file the objection until the injunction petition is disposed of, let there be at least a status quo in regard to the land, which is admittedly now under their possession. But that has not been granted. That's why, my lord, I am before this honorable court, before your lordship. My prayer is that ad interim injunction, otherwise, my lord, the law in Dalpat Kumar is a settled law when it comes to grant of ad interim injunction. The cardinal principles which, my lord, are to be taken into account. Now, in regard to that, my lord, my humble submission is that here, admittedly, the position is that they are now under possession. And we have categorically stated in our injunction petition that we have been dispossessed, and dispossessed by application of illegal force. To that effect, we have even lodged police complaint.
So now you are not in possession
No,
of
my
the
lord, I'm not in possession. So now it has become all the more important that at least till the matter of injunction is adjudicated upon, at least in regard to the scheduled suit property, some protection has to be given. Otherwise, my suit will be rendered infructuous. Not only the injunction petition, my entire suit will be rendered infructuous if the protection is not given. So I understand, my lord, the learned court below might have, my lord, under the regular course of affair, generally what happens, the other side is given a notice, they come, they appear, they file objection, and then eventually the entire matter under Order 39 Rule 1 and 2 is taken care of. But here is a petition, here is a case, my lord, where the requirement of Order 39 Rule 3 is attracted. Now, Order 39 Rule 3, my lord, envisages the circumstance under which an ad interim injunction is required to be passed. And here I have annexed certain, my lord, documents. Your lordship kindly sees why I am saying the anxiety, my lord, that I am expressing, my lord. There are reasons behind that. Your lordship will kindly see at page 97. And this is something that the learned court below has been apprised of.
So how many schedules are there in the suitlet in the title suit?
My lord, the title suit schedule.
Is it the number of 176 title suit?
The title suit, my lord, is the schedule is at page 120, my lord. The title suit number is title suit number 39 of 2025. The title suit plaint I have annexed, the schedule your lordship will find at page 120. And the same schedule is also in the injunction petition, my lord. In the injunction petition, the schedule is at page 136.
So who made these corrections in the schedule?
My lord, your lordship is referring to the corrections in regard.
120, page number 120.
120. This, my lord, was corrected, my lord. This is the office copy that is belonging to the plaintiff. That has been,
There is no initial after correction of this.
that is, my lord, in the court record that correction must have been made, my lord. This is the office copy that I have enclosed, my lord. The schedule,
Is
your
it the
lordship.
certified copy?
No, this is the plaint, the copy of the plaint that.
No, is it the certified copy, certified by the court? No.
No, my lord. This is the copy that was retained by the plaintiff as their office copy. Your lordship will kindly see the schedule in the injunction petition also. That is at page 136. There also, I think, similar correction has been made at continuing at page 137. My lord, what I was trying to, my lord, point out.
Some of the lines have been erased from this.
My lord, some my lord correction has been made. It seems land sold by, that is what is being written over here.
So anyway, let notice go at this stage.
My lord, my anxiety is today. In fact, tomorrow being 11. Tomorrow is the date on which, my lord, this injunction matter is fixed. Suit otherwise has been filed. Suit will proceed in terms of its own course. But so far the injunction matter is concerned. Here, your lordship will see in the, my lord, impugned order at page 139. 11/4 is the next date. That is tomorrow. Now, my lord, admittedly, we have not taken steps for service of the notice as of now, because we are waiting for some kind of, my lord, intervention from this honorable court. The moment we issue notice, the moment they get the notice, knowing that, my lord, we are up to it, our apprehension, my lord, is that they will rampantly start changing the nature, feature, and character of the suitland. They may even go to the extent of alienating. So that is why my humble submission, yes, in this case also, your lordship obviously will have to issue notice because they are to be heard. My prayer is only at this stage, my lord, status quo in regard to the suitland. Because otherwise, everything will be rendered ineffective.
Mr. Chakraborty, you
My lord,
say
my lord.
status quo is also
An interim.
injunction.
It is an interim, my lord. But my prayer.
To grant the injunction, you have to satisfy the three golden principles.
My lord, in that case,
admittedly, the suitland is not in your possession.
Not in my possession, and your lordship kindly sees page 97.
How the balance of convenience is to be determined?
I am to satisfy, my lord, page 97, just for a while, my lord. Page 97, how this possession, my lord, we have lost. That is the crux. My lord, so far the balance of convenience part is concerned, kindly page 97 for a while. This is a complaint before the concerned superintendent of police. May I read this, my lord? It's a short complaint. Respected sir, I, the undersigned, have the honor to appeal before your good self to save me from my treacherous condition, and beg to you that your action could save me from such situation as I state herein below for your kind consideration. That in Kanakpur Part 1 within Silchar town in the jurisdiction of Rangirkhari TOP under Silchar PS in 2nd RS Patta number 52, dag number 146 near so and so. I am the owner of an area of land measuring 14 kathas. Regarding the said land, there is a litigation, that is, a title suit is pending between me and so and so, being title suit number 176 of 2018 in the Court of Civil Judge Senior Division number 1. On such land, there was a godown and 2 residential rooms made of bamboo with tin roofing belonging to me. In such godown and rooms, which was given in tenancy by me and my tenant were occupying such room, on 6/7/2024 at about 1 p.m. said so and so, along with antisocial elements armed with dangerous weapons, that is dao, lathi, etc., forcefully and illegally entered into my such land for taking illegal occupation, and on getting information, I immediately lodged an ezahar before the Rangirkhari TOP. On getting such information, the in charge of Rangirkhari TOP went to the spot and moved said so and other persons out of the land and called me, and those persons in the police station asked us to solve the matter by holding a bichar, and if such solution is not achieved, and then proceed legally. Accordingly, we both the parties agreed to solve the matter by a bichar in mediation of so and so. But as the time frame of the bichar was in continuance, my lord.
Mr. Chakraborty, whether any case has been registered upon this FIR?
My lord, unfortunately, we don't
have any information regarding any registered case. This is a complaint before the superintendent of police. The earlier the complaint was before the concerned police
See,
station.
The problem is that some manipulation in there in the schedule of the suit line.
My lord, that of course your lordship has, my lord, noticed the correction that is there. But that in the main, my lord,
You obtain certified copy of the plaint.
my lord, that can be done. But then at this stage, my lord, my
And
only,
tomorrow the matter is also listed before the trial court.
my lord.
See what happened tomorrow.
My lord, of course, we can maybe file a petition saying that there is a case that has been appeal that is pending before this honorable court. That can be done, my lord. That is possible tomorrow. But my anxiety is that
Let it be immediately after reopening.
my lord will, for the time being, my lord, not issue notice.
Pardon? Here.
Here. Because that is what I am, my lord, asking for. I may be directed to produce the certified copy of the plaint of this title suit.
And you see tomorrow what happened there?
My lord.
Because trial court has not rejected your petition there.
No, that is not there. Only thing we have not taken steps in our own petition because of our apprehension. Because the moment they get the copy of the injunction petition without.
And also you inform this court about the status of this FIR.
Yes, my lord, that will try to collect, my lord.
That's prayed for by Mr. Chakraborty, learned counsel for the appellant. Registers and list the matter on 22nd. 21st.
21st of April, my lord, my lord. My lord, may I just have the direction to obtain the certified copy of the plaint of title suit number?
In the meantime, Mr. Chakraborty shall obtain the certified copy of the plaint and also the status of the FIR lodged with the superintendent of police, Kasar or on which date you have filed it?
My lord, that was FIR was dated 27/11/2024.
27?
27/11/2024.
2024.
My lord, plaint in connection with title suit number 39 of 2025.
Okay.
Title suit 39 of 2025. Obligement.
35. I think 35.
May I please, your lordship? Lordship, I have filed this application in connection with order dated passed on 13/11/24, my lord. I have annexed a copy of order, my lord, case 20, my lord. By virtue of this order, my lord.
So this execution was carried out.
Already carried out, my lord, prior to passing of this order, my lord. Execution degree was executed long back on 26/9/24, my lord, by the bailiff of the court, executive court. This was well within the knowledge and information of the appellant, my lord. But the same was not placed on record. Now, my lord, by virtue of this order, the degree holder has been registered by them, my lord, for getting the fruits of the decree, my lord.
No, you tell me directly whether decree was executed or not.
My lord, executed.
Executed,
my lord. Possession of the dignitary was handed over by the bailiff on 26/9/24, my lord.
So now it is under your position.
My possession, my lord, but they are not allowing me to enjoy the property, my lord, by cultivating the same, my lord, by virtue of this order.
What was the order?
Order, my lord, page 20, 13/11/24, my lord.
Page number?
Page number 20, my lord. Passed by your lordship. I have annexed the same with my IA also, my lord. Page 20 of my IA, my lord.
And what is the execution order?
My lord, execution, your lordship may cannot see. I have annexed the copy of report of the bailiff. It pays 36. My lord, this is translated.
36.
36, my lord. Original order report is
39.
page 37, my lord.
What is 39?
39. This was the position taking over acknowledgement by the degree holder, my lord. Acknowledgement by the degree holder before the bailiff.
26-9.
36-9, my lord.
And the order was passed on 13-11-24.
My lord. But this spec was not
Mr.
placed.
Kolita, so you received the copy of this IF filed by them?
My lord? Yes, my lord. Yes.
So why this misleading statement was made before the court on that day?
My lord, so far, to my instruction, my lord, if your lordship peruse the order passed by your lordship, my lord, 13-11, earlier, my lord, case was earlier listed on, we have filed the my lord, appeal on 15-7, my lord. I'm chronologically coming, my lord. Decree was passed on 16-5-24. We have filed the appeal on 15-7-24. Then, my lord, on 3-10 for the first time case was listed. On that day, my lord, due to paucity of time, case could not be taken up. Thereafter, case was again fixed on 21-10-24. And my lord, your lordship was pleased to direct the appellant to file an amended, my lord, memo of appeal on 21-10. Thereafter, my lord, case was listed on 28-10-24, and lordship was pleased to issue notice on that day. Directing the, my lord, the lordship has observed that whether any execution case is pending or not. At that time, we were not issued with any notice from the executing court, my lord. So, my lord, we are not aware about whether exactly execution case was filed or not. Thereafter, as per your lordship direction, we obtained some certified copy, my lord, and we produced it before your lordship. Lordship order also reflects that by order dated 29-24, the matter was fixed on 1-10-24. And thereafter, again, the matter was fixed on 30-10-24. Till that day, my lord, no report was submitted. So, my lord, as
This position was handed over on 26-9-24.
my lord, on that day, while I moved the petition for the first time, then I made a, my lord, submission verbally that some persons from the, my lord, Nazarat branch has when lordship asked me whether actually any execution case was pending or not, then I have made a submission, verbal submission, that, my lord, some persons went to the Suitland and they tried to measure. That was my submission. Then your lordship directed me to submit, to produce certain documents, whether exactly any execution case was pending. Then on, my lord, 13-11, after perusal of lordship, that certified copy of that order, lordship was pleased to pass this order. So my lord, if your lordship see the order annexed by my learned friend, my lord, first, my lord, page 24, my lord. 24, they have filed a, my lord, execution case on 11-6-24.
Hmm.
11-6, my lord. Thereafter, it was transferred to another court, my lord. And 1-7, lordship will find at page 26, my lord. So he was directed to take steps, and lordship will find the order dated page 28, order dated 29, which I have produced before your lordship, my lord, fixing 1-10 for 24. Then, my lord, 1-10, lordship kindly see, my lord. 110, my lord, it was said that the decree holder represent the report from process service is received fixed for NO, my lord. So what is the, my lord, report, whether, my lord, executed or not, he was not aware, my lord, on that 110, my lord. And on, my lord, 30-10, kindly see, my lord, decree holder is represented, again fixed on 13-11-24 NO. Whether, my lord, decree was executed, possession or handed over, from this order, I have received the order till, my lord, 30-10, my lord. So I have produced it before your lordship. Then, my lord, again, the case was fixed on 13/11. Your lordship, kindly see the order at page 32, my lord. 32 is the order. That order reflects that decree has already been executed, but they have Nazarat branch has submitted the report, my lord, on 30/11. On that day, your lordship was pleased to pass this order. So, my lord, intentional.
You are aware of that date fixed before the learned executing court?
Yes, my lord.
You could have informed this court that today is fixed for order.
Yes, my lord. Kindly see, my lord. I have mentioned, my lord. Your lordship order reflects, my lord. That case was fixed on 29/24. Then matter was, lordship has, my lord, observed that. In the next, the matter was fixed on 1/10/24 and for report. And thereafter, the matter was again been fixed on 30/10. This has been, my lord, observed in the order, my lord. Intentionally, nothing has been, my lord, suppressed, my lord. That is my humble submission, my lord. Because, my lord, he was not issued with any notice, my lord. The judgment letter was not issued with any notice.
May please, your lordship. Lordship, I cannot see. This order has been placed before lordship. My lord, order dated, my lord, page 30. It is speaking enough. My lord, bailiff has submitted the report. They have obtained the certified copy of the report and placed before your lordship. Why they have not obtained the copy of the report? What has been done by the process server, my lord? Was it not their duty, my lord? And my lord, they have placed before this Home Court by the order dated 28th September 24. Writ of delivery of position was issued to the bailiff. This is the order, my lord. 20th September 24. Thereafter, my lord, after execution of the decree, my lord, the bailiff has submitted the report on 1/10/24, which is taken to the record. The execution report is along with the record, my lord, right from 1/10/24, my lord. They have obtained the copy of order, but not obtained the copy of report, my lord. Just to, my lord, suppress the actual fact of execution, my lord.
No, my lord, that was not never
This
intention, my lord.
order sheet shows, my lord. Order sheet shows. And on the day, my lord, this execution report cannot be accepted because PO was only on 1/10/24, my lord. Page 30, my lord. So they are having full knowledge and information that degree has been executed. In spite of that, on 13/11, they praise for stay, my lord. Order sheet, my lord.
Now tell me, what is the way out?
My position should not be disturbed, my lord, that much, my lord. My lord, because they are having liberty, man. If they succeed in the appeal, section 144 of CPC is there, they can take back the position, my lord. Position can be given to them if they succeed in this appeal, my lord. On 144, my lord, CPC. So till then, my lord, I should be allowed, because I am lawful degree holder, I should be debarred from getting the fruits of the decree.
My lord, my learned friend entered his appearance in the month of December itself, my lord. They have filed this petition. Let me submit.
Yes.
They have filed this application, my lord, only now, my lord. So, my lord, if my lord, it was actually, my lord, possession was handed over to him in the month of December, my lord, he could have come, my lord, earlier, my lord. To my instruction, my lord, my lord, appellant is in possession. So, my humble submission, lordship may direct the, my lord, court below to inquire, my lord, who is actually in possession now, my lord. That can be one way, my lord, my humble submission. Because if he is not in
what purpose will be served by issuing such direction? Because until and unless the decree is set aside and cause he is the lawful owner.
To my instruction, my lord, he is not in possession. Because, my lord, I have already submitted, my lord, prior to, my lord, 2020, when the notice was issued on 2010 to 2014, my lord, 24. On that day, some persons admittedly went to the, my lord, suit line, my lord. They measured. But possession was handed over, that was not known to the, my lord, appellant.
That may not be the correct statement, Mr. Polita. You may be correct, but the information furnished to you may not be correct.
Well, on that day, on 28/10, my lord, then lordship was issued notice, my lord, and directed me to obtain certified copy. Then I have made verbal submission to that effect, that some person went to the suit line. But admittedly, my lord, if your lordship sees the order annexed by my learned friend, no notice was issued upon the, my lord, judgment debtor.
Need not require at all, my lord. Need not require. This execution was filed well within 2 years from the date of decree, my lord, put for execution, my
And
lord.
my lord,
No notice requires, my lord.
yes, and my lord, execution was filed without even waiting for the 90 days, which is the limitation period for appeal.
Those are not on the challenge, my lord. Those are
No,
not.
is there any statutory requirement that they have
No,
to
no,
wait
no,
till
that is not
the
one
appeal
of-
period is over?
No, well, I have not filed, my lord.
Then,
Lordship, I cannot see when the writ was issued. Writ was issued well after 90.
Mr. Alam, you tell me, are you in fact in possession of
My lord,
the-
admittedly, my
lord, let
from record, lordship, I am this, my say is not having any legs to stand in the eye of law, my lord. I am saying from the record, my lord. Bailiff has given me position, my lord, by demarcation through lot mandal, my lord. Your lordship, I cannot see report of the bailiff. Annexure E, my lord, page 36. This is translated and originally is 37, my lord. Annexure E, page 36. Today, may I read, my lord? Page 36, my lord, Annexure E.
Not necessary. Not necessary.
Land was demarcated by the land mandal, then mandal has delivered the, shown the land to the bailiff. Thereafter, bailiff had handed over the position to me. Well, from record, I am in possession, my lord. How he can say he is in possession? What document he is having? What proof he is having, my lord?
In record, maybe, my lord, but in physical possession, still I am in possession, my lord. And
No,
my
no,
lord,
a physical possession is delivered to him.
my lord,
This is
You-
not,
is
as per
if your
record.
lordship, may I pray, my lord, for filing an objection to this application, my lord, after taking instruction, my lord, I have received this copy only yesterday, my lord.
No, you could have obtained instruction in the meantime.
Instruction, my lord, I have taken that they are in physical possession. That was my instruction.
Furthermore,
So,
your
my lord,
lordship,
let me file an objection, my lord.
your lordship, may further please to page C page 32, my lord. This is the acknowledgement by the executing court, my lord. This is not under challenge, my lord. Page 32, my lord. Because on that day, presiding officer was in the court, my lord. He has passed this order on 13/11/24, my lord. Seen the report of the process, your lordship may I read? Seen the report of the process server stating that the delivery of cash possession has been handed over to the degree holder over the suit land in presence of witnesses. After degree holder obtained cash possession over the suit land and submitted acknowledgement receipt of delivery of possession, my lord. On record, I am in possession, my lord. How he can say he is in possession, my lord? What document he is having, my lord?
So let me, my lord, rebut this, my lord, his statement, my lord. Let me file an objection, my lord, to that short date, my lord.
Till then, my lord, status quo in respect of possession should be maintained, my lord. Otherwise, my lord, your lordship cannot take a judicial vote. He says, I am in possession. That means, my lord, my possession is going to be disturbed by virtue of stay order.
My lord, he entered appearance in the my lord, month of December, my lord. Within 4 months, he can wait, my lord, but within 15 days, nothing will be happen, my lord. Let me give
No, my lord,
15 days time, my lord.
I have stated in my application, my lord, that since first week of April, he has started creating nuisance. I have stated, my lord. That's why I have been compelled to file this application.
Mr. Koleta, it appears from the record that you were not in possession.
From the judicial.
If you were in possession, that is illegal.
Hex image that, my lord, I have filed the appeal prior to that, my lord. I have filed the appeal, case was moved prior to that. And my lord, order itself, my lord, reveals that, my lord, order doesn't reveal that what was the actual, my lord.
Mr. Alam, let us fix the matter on 22nd or 23rd April. In the meantime, let him file objection.
22nd,
23rd, my lord, let it be on 23rd.
My lord, on 23rd, I shall not be available, my lord. I am having prior engagement. So let me on 22nd, my lord.
22nd. Okay,
22nd.
22nd.
22nd, my lord.
My lord, during this BU case, I may not be able to. I will file the objection on 21st, my lord. I will file the objection 21st. So let it be 24th, my lord. On record, it will come, my lord.
Then 24th, Alam.
My lord.
First, Mr. Alam, current counsel for the applicant, and Mr. Kolita for the respondent, opposite party. Mr. Under this application under section 151 of the Code of Civil Procedure, it's preferred by the applicant.
Respondent number 1.
Or recalling, stroke modifying, stroke vacating the order dated Stay order dated 13/11/2024. Passed in IA civil number 3118 of 24. Arising out of RSA number 187 of 2024. Passed by this court. Passed by this court in IA number I civil 3118. Mr. Kolita submits that he may be granted some time to file objection in this application. There is accordingly allowed recessal is the matter on 24th.
22nd, my lord. 24.
24. So there
Much
is
obliged.
concurrent finding of fact. In the appeal, Mr. Alam,
Hello.
there is concurrent finding of fact by both the court below.
No, my lord. Trial court has dismissed the suit. Appellate court has allowed the appeal.
Okay.
My lord, one thing more, with all respect and regard, my lord. I am placing before your lordship. My lord, one substantial question of law has been framed, my lord. Your lordship, out of record, my lord. This is one of the substantial question of law framed, my lord, at the time of admitting second appeal, because prayer was made in respect of dag number something else and degree has been passed in respect of dag number other dag, my lord. But in this respect, my lord, I have enhanced the copy of certified copy of plaint, my lord, wherein actual dag has been shown. Earlier, this was mistake, my lord. That was corrected as per direction of the trial court, my lord, and reflected in the
Mr.
certified.
Alam, at the time of hearing, we can
My lord,
modify the substance.
my lord,
No problem.
much of.
36, 37.
Sorry, lordship.
My lord, at the moment, I was not agree, lordship. I was unable to, I was on the way, lordship.
Now, are you ready to hear?
Lordship.
May I please, your lordship. I am in item number 37 as the appellant here. And take up this matter first, 37 here. Conducted appeal, your lordship, arranging same incident to appeal file. Ekonojit Nath, MIT 285/22. And the owner of the vehicle here, offending vehicle. In this case, your lordship, we have purchased the vehicle on 29/1/2019. On the very next day, when my vehicle, empty vehicle was proceeding for fitting the person accessories, then met an accident, your lordship, and 2 persons died. Page 11 is the insurance policy, your lordship.
So the accident took place on
31/2019. 19. And we have purchased the vehicle on
And the policy was valid from 29/1/2019.
Right.
So on the date of accident, it was valid.
Valid. On the very next day, it was accident from my purchase, newly purchased vehicle.
Pardon?
Newly purchased vehicle. I have purchased the vehicle on 29/1/19. On the next day, it was accident was took place. When the vehicle was proceeded to the garage to fitting some accessories, then accident. It is a dumper. And the learned trial court, your lordship, tribunal has passed into judgment, your lordship. We start from page 13. Your lordship,
Page number?
13 is start from page 13, 1-3.
Okay.
And your lordship, operative portion, page 23.
So you have filed this petition for enhancement.
No, I am for the owner of the vehicle.
Oh, you are for the owner of the vehicle.
But there is a, your lordship, page 23, the order is given as that the insurance company is directed to pay the amount, awarded amount.
And to recover the
recover
same from you.
Because
the
we have
vehicle was insured.
insured. Next.
Then why the burden is
There is the learned tribunal wrongly for this judgment said that we have no permit was not there.
Pardon?
Permit, road permit, your lordship. Permit of the vehicle.
whether for no, was it a transport vehicle?
It is a commercial vehicle. Dumper,
Commercial vehicle.
Dumper.
So permit is required.
It is required, but there is some exception is there.
Hmm.
Exception is there. Your lordship also not know that.
Yes.
66, your section 66, subclause 3. 66, 3,
66.
lordship.
Section.
66.
Necessity of permit.
Permittal.
Yes.
There is exception. General provision 3 your lordship. Next page. The provision for subsection 1 shall not apply. Permit is required as per section 1. No owner motor vehicle shall use or permit vehicle.
No, you were referring to who is proviso?
3 your
First or
lordship.
second or third?
Third your lordship. General
Third.
exception P your lordship. P to any transport vehicle while proceeding empty to any place for purpose of repair. And my vehicle was empty. Empty vehicle.
To any transport vehicle while proceeding empty to any place for purpose of repair. The newly purchased vehicle.
Newly vehicle. It was,
Where is the question of repairing?
no, it was going to garage for fitting some accessories. Your lordship.
So fitting some accessories, whether it amounts to repairing.
But your lordship, no, on the next day, in for compensation, your lordship, insurance policy is required. Your lordship.
And that's all right. That is a violation of.
No, next day, how can you purchase a permit? Your lordship, your
So
lordship, no.
who will believe that?
We have to apply for the
On
permit.
the
Then
very
after,
next day of purchasing a new vehicle, you have taken the vehicle to garage
Lordship.
for repairing, along with one lady therein.
For accessories, some your lordship, parts. Your
This this is Gitanjali Das has been proceeding towards Porpeta.
There is another vehicle.
Along with Jitendra Verma.
There is another vehicle. It is classic collision of two vehicles. That
So you were the owner of which
owner of the
vehicle?
dumper. Your lordship.
Pardon?
Dumper vehicle. Your lordship. Offending vehicle AS15 AC 2027.
AS15
AC 2027. Your lordship. Purchase on 29/1/19 and next day, on very next day morning, it was accident took place.
Where it is mentioned? Page number?
Which one, your lordship?
Page number?
Number of vehicle, your lordship. Page 6, your lordship, ground
Page
3.
6.
Okay, ground 3.
Page 6, ground number 3.
Your lordship. They purchased the vehicle on next day while the proceed towards garage for fitting some accessories. At that time, accident was happened. The vehicle was empty. The landlord member did not appreciate the fact and applying his like that. After applying the permit, authority consideration issued. It is take time for permit. Your lordship also know that 1 month is required for 15 days. For it. For empty vehicle permit not required. If you will carry the goods with the vehicle, then it's permit required. Empty vehicle need to be.
Where is the accident information report? Page number?
No, I have not annexed there. I have only judgment annexed.
Only judgment.
Findings of the landed trial court, your lordship, page your lordship 21.
21 in this appeal or in
This
the other?
this appeal, your lordship.
Page number 21.
21 paragraph. Start from 20, paragraph 11. Start from paragraph 20, paragraph 11, bottom. May I read?
Yes.
From the materials brought on record by the claimants, it is clearly revealed that at the relevant time, the accident is operating dumper 10-wheeler bearing so-and-so, engine number so-and-so, had been duly covered a valid insurance policy issued by opposite party number 3, HDFC, Representatives Committee so-and-so, policy number so-and-so, with effect on 29/1/19 up to midnight 28/1/2020. But learned counsel for the opposite party 3 has disputed the coverage of the operating tripper by the said insurance policy. It has been contended that the policy premium was paid by the OP number 1 by means of check only, and after collection of the said check, the compliance of section 64(3) of the Insurance Act and insurance policy covering the operating vehicle was issued only 5 to 24, having validity up to 4 to 2020. But the OP number 3 has neither adduced any evidence nor brought on record the original copy of said policy. OP number 1, on the other hand, has exhibited a copy of policy which was issued to him immediately to purchase the
So,
tripper.
you have contested the case before the tribunal.
Criminal contested here.
What is your WS?
WS is a report, but I have not annexed your document.
So the word repair is not defined in the act. But
vehicle was
you have, admittedly, you have taken the vehicle for fitting some accessories. Whether fitting some accessories would mean repair.
This empty vehicle is there. Next day, your lordship, how to permit will in the permit.
Pardon?
For obtaining a permit, it will have to apply, and some days it take time.
That's all right. Why you have taken the vehicle to the road then without permission, without permit?
No, for fitting accessories. For fitting
You
accessories.
could have waited till receiving the permit from the transport department.
Very vague, and And insurance company has filed maybe only for quantum only. And next case, item 36, they have filed this.
You
petition on
tell
quantum.
me,
Yeah,
tell me, what is the meaning of word repair?
Repair means that any damage or something, then really.
No, then-
then
How your case will be covered by this exception? Exception P.
because vehicle is empty, repair means that yes, fitting accessories also. No, it is not repair, not exactly repair. But your lordship knows this always vehicle is empty vehicle, and some all the parts are not fitted at the time of purchase from the showroom. They have to fitting from the garage and the vehicle.
Do you have any decided case on this point?
I have not found any case.
No.
I have not.
If there is no authority with you, then if we go by the plain meaning of repair, then definitely you are not entitled to any protection. Even then, I'm giving you time to produce some authority if there is on this point.
I will try after vacation. I try. After vacation, I try that. I thought that the
Mr. Goswami?
connectance is for the appellant. The another appeal is connected. Item 36 for the appellant.
You are for the appellant?
Insurance company.
Insurance company.
They have selected.
So what is the ground of your appeal?
Quantum.
See, it's in quantum, the income has been taken as 1/3 of the income of the husband, lordship. I agree with you. That's the here. It's around 16,000 it was taken. But lordship, the judgment said that although there is no document has been, he believes in that. Now that creates a legal problem, lordship. If the claimant even now can show what is the income of the husband. The presumption is that husband income is so much, 1/3 should be taken. She was a housewife, homemaker. The more respectable word is homemaker nowadays. That is a housewife. But here my ground of vision that it has been taken as 16,638.89 per month. As such, the presumption of income, this is as a
that is also national income or what?
No, the husband was a serving person.
Serving person.
He is working and his income could have been definitely. I'll just read out the particular part of the judgment why strict proof could not have been insisted upon. Although no proof in that regard has been produced, the same appears to be reliable.
Which paragraph you are reading?
Page 8 of the judgment, lordship. Paragraph 15 of my memo.
Page 8. Paragraph number?
Paragraph number 9, lordship.
9.
That's a very limited ground, lordship. On this.
Okay.
It could have been lesser also. I'll be paying a little more if it is less.
9, yes.
9, lordship. Page 8, lordship.
Page 8. Yes.
8. The Honorable Apex Court in the case of Arun Agarwal versus HDFC Argo General Insurance Company, has filed that in the case of a spouse, 1/3 of the earning spouse should be taken as his or her contribution earning for the purpose of compensation. Claimant number 1 during preliminary examination stated that being a government servant, received monthly salary of rupees 51,000 at the time of relevant time as stated by him during his preliminary examination. Claimant number 1 stated that he also paid so-and-so as income tax. As such, his net is shown 49,000. Although no proof in that regard has been produced, the same appears to be reliable, lordship. The insurance company did not have any chance to go through it, whether that income was inclusive of arrears, sometimes area payment. On what basis had he made that statement? Simple requirement, lordship. They can still produce the. It should be available, lordship. The claimant is still alive, only the wife has died. Sometimes, lordship, salary slips are produced
which includes some areas, that is not his monthly salary.
No, definitely.
That proof should have been there. If that is the source of presumption, the source should be defined.
So Hussein,
Ahmed Lordship. I'm Ahmed Lordship.
so do you have any salary slip?
My lord, salary slip, lordship, in the findings, lordship, it is stated, lordship. My lord, in cross-examination, my lord, it is CW1 cross-examination, lordship. During cross-examination, it is stated, lordship. Once, my lord, cross-examination, my lord, answer comes positive. It cannot be, my lord, discarded.
No documentary evidence was given.
But even then, this documentary evidence is the best evidence. Huh?
No debate at all.
Now it is kindly see, my lord, judgment, it is discussed, lordship. My lord, reason, decision and reason is at page 12, lordship, of the other, my lord, MSc appeal number 832.
No, this is the same judgment which is being impugned in both the appeal.
My judgment, yes, lordship. Now, the Honorable Supreme Court, my lord, has specifically.
That principle I have not
this is a
disputed,
proposition of law, lordship.
Proposition of law I have not disputed.
Now, kindly, my lord.
It's only on one specific point, whereas 51,000, 41,000, 31,000, that he has said.
My lord, kindly see the, my lord, judgment decision, my lord. It is discussed in detail, lord.
Not
My lord, at
dispute.
page 12, lordship. My lordship.
Yes.
Claimant number 1 has examined himself and another person, namely Sri Brozen Uza, CW2, as witness in support of the case and filed claim and by claimants. Claimant number 1 has also exhibited various documents and medical certificates for the purpose of establishing the case in their favor. The opposite party, respondent number 1, owner of the dumper, has also examined himself as a defense witness, DW1, in support of its case. From the evidence of witnesses and the materials brought on record, particularly the accident information report on form number so-and-so, coupled 54, Exhibit 1, coupled with the certified copies of FIR and FIR dated 30/1/2019, Exhibit 1, postmortem report of the deceased Gitanjali Das, Exhibit 3, and all other materials available in the case diary of Howley PS case number so-and-so, IPC, including copies of the FIR dated the inquest report, extract copy of Howley PS CD number and GDM number so-and-so dated 30/1/2019, sketch map, search sheet number so-and-so dated 31/3/2019, Caesar list, reports of MBI, etc. It is quite clear and evident that the alleged accident had taken place on 30/1/2019 at about 11 a.m. at Kodamguri on the Howley-Barpeta PWD route under Howley PS in the district of Barpeta, Assam, with the involvement of 2 motor vehicles bearing registration number so-and-so and bearing chassis number so-and-so and the engine number so-and-so, causing instantaneous death of claimant's wife, mother, daughter, Gitanjali Das, and the driver come owner of the Maruti car, namely Jitendra Bormon, and in respect of which a police case got registered at Howley PS as Howley PS case number so-and-so under section so-and-so. Claimants have attributed cause of accident to the rash and negligent manner of driving of offending dumper 10-wheeler by its driver opposite number 2. This being a case of composite negligence has rendered the issue of rash and negligent driving inconsequential, as the claimants have the liberty to raise their claim from the owner and insurer of their of the colliding vehicles. That being the case, and the
Mr. Ahmed, you showed me the cross-examination part.
my lord, cross-examination, next paragraph, lordship. My lord, This is important law. That being the case and the alleged accidental death of Gitanjali Das having been provided, the question now arises as to what would be the quantum of just and fair compensation and who would be entitled to receive pay the same. Claimants being the husband, son, daughter, and mother of the deceased have raised this claim being her legal heirs and the representatives. Now, before determining the question of dependency, it is important to ascertain as to whether deceased was an earning or non-earning member of the family at the time of her death. The claimants have asserted that the deceased worked as tailor in Shambhu Ladies Tailoring at Barpeta Route, wherefrom she used to earn an amount of rupees 15,000 per month. They also stated that deceased also earned an amount of rupees 5,000 from animal husbandry and at the time of death. To prove such contention, claimants have failed to produce any kind of evidence, either documentary or otherwise. In fact, CW1, this is my lord, CW1 during his cross-examination stated that his deceased wife was a housewife. Deceased as such shall be considered to be a non-earning member of the family. Since the deceased was a housewife mother, the claimant number 1, 2, 3, husband, son, and daughter of the deceased got equally affected by her death. As such, the claimant number 1, 2, 3 would be considered to be the dependents in the present case. Claimant number 4, mother of the deceased, although claimed herself to be a dependent of her deceased daughter, but she cannot be considered so. CW2, namely Bazen Uza, during his cross-examination, stated that his mother used to live equally in the house of the siblings. There is no evidence on record also to show that the claimant number 4 all along lived in the house of her son-in-law, that is claimant number 1. The said contention is thus rejected. Now, to establish the age of the deceased, claimants have produced both the PAN card and electoral photo identity card of the deceased. It is seen that
Where is the finding
lordship
regarding the income?
Income lordship, my lord, paragraph lordship, next page lordship. Before after the discussion of the judgment lordship, my lord, as regards case law, it is my lord discussed. My lord, page number 15, lordship. Honorable Apex Court in the case of Arun Agarwal versus State of HDFC ERGO General Insurance Company reported in year 2010 HC 3426 paragraph 35 has held that in the case of spouse, 1/3 of the earning spouse should be taken as her contribution earning for the purpose of computation of compensation. Claimant number 1 during preliminary examination stated that being a government servant, sub-engineer in the PWD drilling division, Bopeta, received monthly salary of rupees 51,000 at the relevant time, as stated by him during his preliminary examination. Claimant number 1 also stated that he also paid income tax of rupees 13,000 approximately for the AY 2018-19. As such, he has net monthly earning of rupees 49,901.16. Although no proof in that regard has been produced, the same appears to be reliable. Considering the same to be the basis, deceased earning in the present case would be rupees 16,638.
So, Mr. Ahmed,
Lordship.
you see, you have income tax assessee also. You have not produced any document of deduction of income tax, even this Form 16 also. And you have not produced the salary slip also. So how can this be believed?
But in the statements, in the judgments, judgment lordship, so far discussion is concerned, lordship. My lord, there is no, my lord, denial of the, my lord, denial of this statements, lordship.
Maybe that may be.
Denied, lordship. It is not denied by the during cross-examination of my lord. If it is not denied, lordship, this is positive statement.
No, no. Tomorrow, if you claim that your monthly income is 10 lakh, unless you produce any document in support of the same, who will believe it?
My lord, in the my lord, memo of appeal, my lord, access judgment, my lord. No other document is also annexed, lordship. Then, my lord, it may be fixed, my lord. I will, my lord, take instruct whether, my lord.
No. If he is a service holder, you produce his salary slip. And if he is an income tax assessee, you produce this Form 16 for that particular year when this assessment was carried out by the learned tribunal.
Lordship. It may be fixed, my lord, on other date, lordship.
So merely because somebody submits that his income tax is 13,000, who will believe it?
My lord, statement is there, lordship.
Statement is there.
Income and age is always the burden of the claimant to be.
My lord, in a case, lordship, the Honorable Supreme Court, my lord, that is 2019 2 HCC 186, lordship.
You are
This is held the
quoting
non-execution
this,
of
judgment from the book.
my lord, that is your life. My lord, it may be fixed on other date, lordship. My lord, my lord,
Okay,
non-execution
we will
of documents.
keep the matter as parted.
Yes, lord.
Okay. Heard Mr. Goswami, learned counsel for the appellant in appeal number 285.
Yes, Lordship.
285. That Mr.
Mine is also appeal number 332.
332. 332. And Mr. Ahmed for respondent number.
My lord, in respondents claimants. Respondent numbers. Lordship. 1, 2, 3, and 4, lordship.
1, 2, 3, and 4. And Mr. Islam for
5 and 6.
5 and 6. Heard in part, list
Yes,
the matter for further hearing on February 30. Yes. In MSc appeal number, item number 37, it declared heard Mr. Islam, learned counsel for the appellant, and Mr. Ahmed for respondent number.
My lord, 1, 2, 3, and 4.
1, 2, 3, and 4, and Mr. Goswami for respondent number.
In this case,
in that case,
number 6, Lordship.
6.
Yes.
Respondent number 6. Heard in part, lays the matter along with MSc appeal number 332 of 2021 as parted.
Obliged.
Obliged.